morning, everybody. Happy Friday. Welcome to TCF Live. Happy to have you here. We'll start our day in Michigan. Judge Middleton.
So we are on the record. Let me take a moment and swear you in. Would you please raise your right hand? Do you swear from the best of your ability you will interpret these matters from Spanish into English and English into Spanish? You're on mute.
My apologies. I do.
And would you state your name, please?
Vivian Montero, Court Interpreter 18369.
Laura, that computer is making weird little gurgling noises again. All right, let's begin with Diego Gomez Lopez.
Vamos a empezar con Diego Gomez Lopez.
No, sorry.
Buenos dias.
Buenos días.
As you said, Diego Gomez Lopez.
Sí.
The lady on the screen, her name is Vivian Montero.
La señora en pantalla se llama Vivian Montero.
And she is going to interpret for us.
Ella va a interpretar para nosotros hoy.
Because I don't have any Spanish.
No tengo nada de español.
And I want to make sure that you understand everything.
Quiero asegurar que usted entiende todo.
You got arrested for operating while intoxicated on Christmas Day.
A usted le detuvieron por conducir en estado de ebriedad el día de Navidad.
Sí.
They also charged you with speeding.
También enfrenta el cargo de exceso de velocidad
And not having a valid driver's license.
y conducir sin tener una licencia vigente.
You're here with your lawyer, Rhonda Ives.
Se encuentra aquí con su abogada, licenciada Rhonda Ives.
And the file number is 252646ST.
El número de caso es 252646 SD.
The prosecutor has agreed to dismiss the speeding charge and the
El
no
agente del
license charge.
El agente del Ministerio Público está dispuesto a desestimar el cargo por exceso de velocidad y el cargo de no licencia
And the drunk driving charge
y el cargo de conducir en estado de ebriedad.
if you enter a plea to operating a motor vehicle while impaired.
Si usted contestara culpable al cargo de conducir un vehículo con las facultades disminuidas.
Impaired driving in Michigan is a misdemeanor.
Conducir con las facultades disminuidas en el estado de Michigan es un delito menor.
It is punishable by up to 93 days in jail
Conlleva una máxima penalidad posible hasta 93 días de cárcel
and a fine of up to $300.
y una multa hasta $300.
It carries 4 points on your driving record
Conlleva 4 puntos en su historial de conducir
and it would require that your driving privileges be restricted.
y va a requerir que se le restringe su privilegio de conducir.
But you don't have a valid license anyway, so that may not matter so much.
Pero usted no tiene una licencia vigente, así que tal vez eso no importa tanto.
Are you going to enter a plea of guilty to the lesser charge of operating a motor vehicle while impaired?
Usted va a contestar culpable al cargo de gravedad reducido de conducir con las facultades disminuidas. ¿Sí o no?
Sí.
You have to speak up so that can,
Yeah, so, yes.
Tiene que hablar
Did
en voz
anybody
alta.
threaten you to try to get you to plead guilty to that charge?
¿Alguien le amenazó para que contestara culpable a ese cargo?
Let me ask this again. Did anybody threaten you to try to get you to plead guilty to that charge?
Déjeme hacerle la pregunta de nuevo. ¿Alguien le amenazó para que contestara culpable a ese cargo?
No,
Did anyone promise you anything that would happen if you pled guilty to this charge?
¿Alguien le prometió algo para que usted contestara culpable a este cargo?
Other than these other charges would be dismissed for a plea to impaired driving.
El acuerdo es que los otros cargos serían desestimados si usted contestara culpable al cargo de conducir con las facultades disminuidas.
Nobody promised you anything?
¿Nadie le prometió algo?
no,
Do you understand that by pleading to this charge, you're going to give up these rights, including the right to have a trial that were given to you in Spanish?
Usted entiende, al aceptar el acuerdo para resolver el caso, usted está renunciando a su derecho de llevar el caso a juicio y todos los derechos que está en esta hoja que usted firmó, e inclusive I lost my train of thought, Your Honor. Giving up your rights for a trial, including
The right to have a lawyer and have a trial.
el derecho de tener un juicio y el derecho de tener un abogado que le representa en un juicio. ¿Entiende usted eso?
Understand?
sí,
Yes.
All right. Were you driving a car in Constantine on Christmas Eve just before midnight?
Usted estaba manejando un auto en Constantine en la víspera de Nochebuena, antes de la medianoche.
sí.
Where were you going?
¿A dónde iba?
A, la gasera,
¿A dónde?
a la gasera, a la
Interpreter
gasolinera.
a la gasolinera. Okay, to the gas station.
Where had you been drinking?
¿Dónde estaba cuando se puso a tomar?
Bueno, allá en Constantine, es que me invitaron a comer, compañeros de la casa y me invitaron, ven a comer, me dijo, no, le digo, pues ven a comer porque hoy estamos en Navidad. Bueno, pues, voy entonces, porque yo vivo aquí, ahí nomás cerca. Y luego, pues, así comimos y ya, me invitaron a tomar cerveza y luego, se acabó la cerveza y vamos a comprar más, dicen los demás. Ok, vamos. Bueno, yo pensé que...
You have to speak in
Okay.
short sentences.
La intérprete tiene que interpretar todo, tiene que hablar pausadamente. So there were some friends in Constantine. Since it was Christmas, they invited me over to eat, and we drank some beer. When the beer ran out, we went to get some more.
How many do you think you had?
¿Cuántas cervezas cree usted que había tomado?
Pues, como seis
Maybe
cervezas.
six. Maybe six beer.
Kind of beer was it?
¿Qué tipo de cerveza era?
Modelo.
Modelo.
Your blood alcohol was 0.139.
El nivel de alcoholemia era .139.
on the preliminary breath test.
En la prueba con el alcoholímetro.
Will you accept that?
¿Aceptaría eso?
That's more like about 10 beers.
Es más parecido a 10 cervezas.
All right, I will accept your plea. And the next
Voy a
thing we need to set the matter for sentence.
Voy a aceptar su contestación de culpable. Lo que tenemos que hacer ahora es fijar fecha para la imposición de la condena.
So let's find a date that works for our interpreter and for your lawyer.
Vamos a fijar una fecha que trabaja bien para su abogada y para la intérprete.
Rhonda, I keep forgetting when you're going to be gone.
It is the last week of March, Your Honor, through April 9th, pretty much. I should be back on Friday the 10th.
Are you available on Monday, March 23rd?
Monday, March 23rd. Boy, I have a 10 a.m. in Branch County of felony sentencing.
Yeah, that won't work. Ms. Montero or somebody is set to be here that day. How about Wednesday, March 25th?
Yes, Your Honor, I'm actually before you at 11 a.m.
Yes, we got Kaylee Ruth. So let's set this for Wednesday, March 25th at 10:30. Vivian, are you available that day?
I'm available that day, but not at that time. But I guess there's a backup interpreter in case I can't make it.
Okay, because I'm going to set
don't worry.
both of these for the same day. Ms. Ives is about to be gone for a while, and I'd like to get this done before that. So we'll use that day. She's set to be here that day anyway. All right, we're scheduling this for sentencing for Wednesday, March 25th at 10:30.
I'm sorry, Your Honor, could you repeat that date and time? Wednesday?
We're setting him for Wednesday, March 25th at
Okay.
10:30.
Señor, entonces la próxima audiencia, la imposición de la condena sería el día miércoles 25 de marzo a las 10:30 de la mañana.
I'm going to send you out to the counter where the clerks will give you some information about coming in for sentencing that day.
And as they spend 10 minutes explaining to him via interpreter where the counter is, good morning, everybody. Happy Super Friday. Welcome to TCF Live. Ellie also says hi. We're both happy to have you here with us. Let's stay in Michigan. Let's head north, though. Wexford County and Judge Elmore getting his day started.
For the 28th Circuit Court here in Wexford County. And we are beginning today's docket call by taking up the case of People of the State of Michigan versus Brooke Halliday. This is file number 25-14132 FH. Appearances from counsel, please.
On behalf of the people, and I'm Jeff Harrison. I'm here on behalf of Brooke Halliday. That is her on the video screen.
Thank you very much. Ms. Halliday joins us today from the jail over in or up in Grand Traverse County. Ms. Halliday, are you able to see the court?
Yes.
All right, thank you very much. Also before the court this morning is Miss Alex Matsky. She is patient with the Western Misaki Community Corrections Program. It looks like we're for an arraignment on a bench warrant. The bench warrant was issued by this court back in February. I'm sorry? October, yeah, that looks like October, about October 20th, 2025. 1 second, I'm almost getting there. All right, I actually issued it on October 17th. Miss Halliday, I need to tell you that, one, you're here today for an alleged bond violation. Specifically, it's alleged that this case was set for a final pretrial conference to occur on November 7th of 2025. And that was removed from the docket and you failed to appear because allegedly on or about October 15th of 2021, you failed to appear for drug testing as ordered, which was a condition of your bond. Now, this could be considered an allegation of contempt, but we do not treat it as that. Contempt could get up to 90 days in jail and $7,500 in fines and costs because it could be a failure to follow a court order. This court, however, treats it as a review of your pretrial release conditions pursuant to a Michigan Court Rule 6.106 parenthetical H. You have the right to have a hearing on the matter. It's not a trial, but it's just a short hearing where Ms. Matsky would be called here to testify and would basically tell us whether or not you had been advised that you had to have your testing done and whether or not you did or did not appear. If you are found to be in violation of your bond conditions, the bond could be continued, or it could be revoked, or it could also be modified. Now that I've covered what the allegation is, why we're here on the record today, and what the choices are, as well as the possible consequences, I'm going to turn to Mr. Harrison. Mr. Harrison, have you been able to speak with Ms. Halliday about this matter?
I have through, at least once while the bench warrant was pending.
Okay.
I would have this set for a hearing because I'm unsure as to the current state of the negotiations to resolve the case. We may be able to resolve everything all at once.
Well, well, we could do that, but let's do it this way because it's not going to really impact the change.
Right.
Ms. Maskey, please raise your right hand. Do you swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
The court takes it as a notice that this is Alex Matsky, who works down in the Community Corrections Office, and that office is in charge of conducting random drug or alcohol testing. The court also takes judicial notice that the terms and conditions of bond, which were set by the 84th District Court and continued by this court, included that the defendant is not to possess or use any illegal or controlled substances and would be subject to random testing. Mr. Carnes, go ahead and ask your question.
Ms. Matsky, is it true that Ms. Halliday was required to submit to random drug testing through your office back in September, October of 2025?
Yes,
On what date was that?
she was ordered to. It was September 10th that the bond order was signed in district court.
And what, if any, contact did you have with Ms. Halliday following that order?
On October 9th of 2025, she enrolled in random drug and marijuana testing.
Was that the date she was released from jail?
I believe so, yes.
And after enrollment, was she ordered in for random testing?
She was.
On what date?
She was ordered in on October 15th, October 18th, and October 23rd.
And did she appear on any of those days?
She did not.
Did you receive any contact from Ms. Halliday after she signed up for the testing program?
We have not.
Thank you. I have no further questions.
Mr. Harrison, any questions for Ms. Matsky?
Yes, Ms. Matsky, is it your testimony that Ms. Halliday was given some kind of either verbal or written notice by your office on the 9th of October?
Yes, it was, she would have been given a copy of her rule sheet that was signed on the 9th of October, and then we verbally explained the rules as well.
Okay, you're speaking in the hypothetical. Can you testify here today that either of those took place for certain?
Yes, I have a signed rule sheet from her on the 9th of October, and then I verbally explained rules to every defendant, and I signed that I was the one that enrolled her.
Okay. Well, it's actually your signature on the verification of that. That's why you're saying that.
Correct.
Okay, thank you. Nothing further.
Anything further, Mr. Carnes? Anything from the defense?
But no proofs at this time, Your Honor.
Thank you. The court finds the defendant has violated the conditions of her bond by failing to test. In fact, we haven't known where she was now or has been for nearly 5 months. Therefore, the court revokes the defendant's bond and remands her into custody. The case will be immediately set upon the court's docket for the processing of this case. I believe our next step is to have the case set for a final pretrial conference. That will be on a upcoming Friday, and then there will also be a trial date set. And so we should be back here on the record. Well, I don't know exactly when, but it'll probably be in a couple weeks. If the parties reach a resolution and they wish to have the matter brought before the court for the entrance of a resolution, they can contact the court staff and get it on the docket. Now that, of course, is stated only as an option. I have no opinion about the facts of the case or what the parties should do, but I'm just letting them know we will probably take a couple weeks, maybe a month before the case is back on the docket. Anything else today, Mr. Carnes?
No, Your Honor. Thank you.
Anything else today, Mr. Harrison?
Nothing further, Your Honor. Thank you.
All right. Ms. Halliday, have you been able to continuously see and hear the court this morning?
Yes.
All right, ma'am. Thank you. Are you currently in Grand Traverse County? Been arrested there on some new charges? I don't need to know anything about it. Just, is that what happened?
Old charges.
Old charges? All right, thank you.
Yeah.
I'm just gonna make it. All right, the only reason I'm doing that is so I can make a note here in the file that that's where you may be. So just 1 second. All right. Thank you very much. We are adjourned.
Good morning once again, everybody. TCF Live. It's a Super Friday, as we do here. We don't do regular Fridays. Regular Fridays are for losers, and we're winners here. So it's a Super Friday. Let's stay in Michigan, go down to Lenawee County. Judge Olsaver. See what's going on there.
Do you want to go back in the breakout and talk more about that, or?
You could. The
I mean,
recommendation.
you didn't have any questions for me. I know you said you wanted to review it though. So are you sure you're okay with me signing them
Yes.
on your behalf? Okay. So, Your Honor, I guess we're ready to proceed on the record then, if Your Honor is okay with that. There is a plea agreement for Mr. West in these files. He was pleading to operating while intoxicated, third offense in both files, both 20069FH and 2522294FH. The people would agree to not file an absconding charge in regards to the older file, the 20069FH, as well as they would recommend 6 months jail in regards to Mr. West's sentence. Previously, there was a plea agreement with a recommendation or no objection to entering sobriety court. But again, the agreement, as I understand it now, is that they would recommend 6 months jail. That agreement was, like the last time we had that agreement, that was back in July. So that is the agreement at this point, and I discussed that with Mr. West, and he is wanting to enter a plea again to operating while intoxicated, third offense in both files.
Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Mr. West, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
Mr. West, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention in file 25-22294-FH to plead guilty to count 1, operating while intoxicated, third offense?
Yes, sir.
Is it also your intention to plead guilty in file 20-20069-FH to count 1, in that file, also operating while intoxicated, third offense?
Yes, sir.
Do you understand, with respect to each of those counts, the maximum possible penalty is a fine of $500 to $5,000 and either 1 to 5 years incarceration or probation with 30 days to 1 year in jail, and at least 48 hours of those to be served consecutively, and 60 to 180 days of community service?
Yes, sir.
Do you understand that that also requires mandatory vehicle immobilization of not less than 1 year or more than 3 years?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
That's correct, Your Honor. That's correct, Your Honor.
So let me just clarify what the sentencing agreement is, because Mr. Murphy, all I heard you say was 6 months in jail. Did you mean you would also be on probation? Because if it's a 6 months jail sentence, the probation is required.
Yes, Your Honor. I mean, that's, again, the recommendation from the people was for 6 months jail. Again, my understanding was that was covering any incarceration time. Mr. West is going to ask for to go to rehab, and he's expecting to be placed on probation, I believe was the expectation. I don't think there was an expectation of the jail time encompassing the entire sentence.
Okay, is that your understanding, Mr. West?
Yes, yes, sir.
All right, I just wanted to make sure we had a clear record of that.
Thank you.
If a guilty plea is accepted, there'll be no trial. That means, Mr. West, that you're giving up the rights that you would have had at trial. I'm going to explain those to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. West, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead in file 25-22294-FH to the charge that on or about May 3rd, 2024 in Cambridge Township, Lenawee County, Michigan, that you did commit the offense of operating while intoxicated, third offense?
Guilty.
And how do you wish to plead to the charge in file 20-20069-FH to the charge that on or about September 3rd, 2020 in Rome Township, Lenawee County, Michigan, that you did commit the offense of operating while intoxicated, third offense?
Guilty, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
You understand that if I accept your plea, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas.
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. West to plead guilty today?
No, Your Honor.
Your Honor, I wanted to place on the record, we did have a Cobb's conference scheduled for later in the month. Mr. West asked to have the plea entered without going to that Cobb's conference and getting an official answer from the court. I did let Mr. West know that it is my intention after he enters the plea to request the court to consider releasing him early, either after the pre-sentence investigation report is done, or whenever the court finds appropriate, to release him to rehab. So I was going to place on the record again, that was something I talked to him about what I intend to do after the plea. So other than that, there was nothing else that was promised to him.
Okay, so Mr. West, you understand that regardless of any discussions you've had with Mr. Murphy about that issue, that ultimately I'm going to be the one to make that decision, and I could decide either way.
Yes, sir, I do.
Okay, and do you still want to move forward?
Yes, sir.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir, I do.
Is it your own choice to plead guilty?
Yes, sir.
Mr. Murphy, would you like to establish the factual basis?
Yes, Your Honor. Thank you. Okay, I'll start with the older file 2020069FH. Mr. West, were you indeed in Rome Township, the County of Lenawee, the state of Michigan, on or about September 3rd, 2020?
Yes, sir.
And on and about that date, were you operating a motor vehicle on US 223?
Yes, sir.
And while you're operating that motor vehicle on US 223, was your blood alcohol content indeed over 0.08?
Yes, sir.
And would you agree that by virtue of your blood alcohol content being over 0.08, that your ability to operate that vehicle was impaired, that you were intoxicated?
Yes, sir.
And do you indeed have prior operating while intoxicated offenses on your record, specifically one from April 15th of 1988 in the 2A District Court for Lenawee County, and another one in April 28th of 2004 in the 79th District Court of Mason County, Michigan? Does that sound accurate?
Yes, sir.
John, I believe I satisfied the factual basis for that count. So for that charge, I'll move. Mr. Sneeder.
I am satisfied, Judge. Thanks.
Thank you.
All right, I'll move on to the next file. Thank you. Let me see. So in file 2522294FH, Mr. West, were you indeed in Cambridge Township, the County of Lenawee, State of Michigan, on May 3rd of 2024?
Yes, sir.
And were you indeed operating a motor vehicle on US 12, a public highway?
Yes, sir.
And when you're operating that motor vehicle on US 12, was your blood alcohol content over 0.08?
Yes, sir.
And again, you would agree that by virtue of having a blood alcohol content, what it was, your ability to operate the motor vehicle was impaired and you were intoxicated?
Yes, sir.
And again, you have those priors I just placed on the record for that previous case. You have those priors, obviously.
Yes, sir. Yes, sir.
Your Honor, we are satisfied the factual basis for this charge.
Mr. Sneed,
I am, Judge. Thank you.
has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you, Your Honor.
Mr. Murphy?
Yes, Your Honor, thank you.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. West has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for April 17th at 8:15 a.m. Mr. West, someone is from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir.
Your Honor, may I address his bond?
You may.
We'd ask the court to consider after his interview is done and after the probation department's completed with him, if he could be considered, if Your Honor consider allowing him to be released to an inpatient rehab. He's been hoping to, if that was to happen, to get into like Don Farm, some long-term treatment facility. I think I expressed previously, Your Honor, the reasons why I would think it was appropriate for Mr. West. Again, he's taking responsibility. He's not, I mean, he understands the severity of the situation of what, you know, quite frankly, he has 2 OWIs he pled to today. Obviously, he's fortunate that he wasn't ultimately charged with absconding from the previous one that was almost 6 years ago now. But I think in regards to the situation, a period of time in an inpatient rehab would benefit him. That's why I'm asking for it to happen, you know, almost as soon as we can, if the court would agree to that. Obviously, the recommendation for 6 months jail from the people, you know, I guess would address that, how it would come up, if it would be suspended or how the court would address that. But I would ask the court to consider, again, releasing him after the probation department needs him here, allowing him to be released to an inpatient rehab.
So at this point, he has agreed to a 6-month jail sentence. I think I would be, I'm also concerned, you know, frankly, about what has happened and what is an appropriate consequence for what has happened. And so I would be perhaps willing to consider that at sentencing, but not at this point.
Yes, Your Honor.
All right, Mr. West, you can let the officer that's with you know that you are done with court for today.
All right, thank you. Have a nice
Thank you,
day.
Your Honor. Mr. West, I'll talk to you again soon, okay?
Yes, sir.
Okay, friends, let's change it up. We'll head down to Florida, do our almost daily check-in with Wade Mercer, see what's going on.
Here, you've got an auntie and some cousins here in the courtroom, some family members. Ma'am, you're here because you've been accused of 1 count of domestic violence battery. Ms. Kirkland, there is probable cause for the charge, ma'am, but the good news is I don't see any criminal history. Have you ever been arrested or charged with a crime anywhere?
No, sir.
All right, so what I'm going to do is I'm going to appoint the public defender's officer to represent you for first appearance purposes, ma'am. Listen to Mr. McDaniel, and we'll listen to the state, and then we'll go from there. Mr. McDaniel, anything?
Your Honor, just that, you know, she's local, lifetime resident here, never been in trouble before. I think 47 years old. We just asked the court to 47, 48. We'd ask the court either for a cash bond or RRF, have her come back for the court hearing, whichever the court deems is appropriate. And I've talked to her about having no contact with the person here. Obviously, there's some disagreements of whether they were living together. You know, whether someone comes over and visits a few nights a week over a month's time, you know, here and there, that's something we'll deal with later. But I'll let her know that if he's there, you know, she don't need to go back. She needs to do something, you know, something separate.
Thank you. And Mr. Gill, any thoughts?
Judge, I've reviewed the complaint. We're just asking for no contact with the alleged victim.
Any objection to the cash bond?
No objection to cash bond.
So, Ms. Kirkland, I'm going to let you pick between a conditional release and a cash bond. I'm sure that Mr. McDaniel has already explained the difference to you, but you are going to be offered an option. If you choose the cash bond, it'd be $250 cash because of your lack of criminal history. There is a condition of no contact. I'm not real clear. The complaint doesn't give us a lot of information, as Mr. McDaniel said, about whether the person has to be evicted or can they be trespassed. And I don't know the answer to that question, but they have to be lawfully removed before you can go back to that home. So you would have to contact law enforcement if they're still there and seek some guidance. If law enforcement tells you they're not going to trespass them, then you have to go through some type of other removal process legally. Do you have somewhere else you could stay on a temporary basis if that person was still in your home?
Yes, sir.
Okay. And you understand your difference between the cash bond and the conditional release?
Yes, sir.
And which one do you prefer, Ms. Kirkland?
The cash bond.
So it's a $250 cash bond. So let me talk to your family for a second. So what that means is as soon as $250 cash are posted at the jail, she'll be released immediately. So if you do that this morning, she'll be out this morning. She just can have no contact with that person. If that person's out of the home, she goes home. Fine. If he's still living there though, she has to legally remove him, and that gets complicated because law enforcement has to interpret, is he just an overnight guest, in which case they can just tell him to leave? Or is he been there long enough to establish a residency, which means she would have to file some type of legal action to have him removed. It's not a landlord-tenant case. It's a different type of legal action. So that gets kind of a little confusing. It's not something we can deal with this morning. The other thing we're going to do is I want to give you a notice for your court date. We'll get so she's getting a cash bond. We'll ask the jail to give you a notice. Her court date would be when? March the 30th. At 9 a.m. will be your court date. Ms. Kirkland, do you have any questions?
No, sir.
Family have any questions? They said they'll get you out of jail, okay? They'll get you out this morning, hopefully, okay?
All right, thank you.
Thank you. Have a good day.
You too.
After Ms. Kirkland, we have Jay Bunting next. Bunting, good morning. Mr. Bunting, you're here for first appearance accused of one count. Well, you have a charge of failure to appear on the offense of battery and a violation of conditional release warrant on that same charge. Mr. Bunting, your father is in the courtroom. I'm going to appoint the public defender's officer to represent you for first appearance purposes and ask that you listen to your attorney, please.
Yeah, just to correct the record, it was not a failure to appear. I mean, he was in jail in Washington County, but we're going to enter a plea of no contest to the charge as listed. Understanding he'll be sentenced 30 days in the county jail, $722 fine, 4 days jail credit. He signed his plea waiver form, waived his right to jury trial and call witnesses. That'll resolve this case today.
Thank you, Mr. McDaniel. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
And Mr. Bunting, did you hear that agreement?
Yes, sir. There's not a better
Yeah.
deal for me though. I know
Well,
that's-
considering that's your own conditional release and you got charged with new felonies in another county and then pled those felonies, that's the offer being made today. Do you want to accept
Okay.
that offer or not?
If that's the best they can do, yes, sir, that's what I'll accept.
All right. So, Mr. Bunting, I'm going to accept your admission or your plea of no contest to the offense of battery. I don't remember his criminal history before this, so let me take a look at that on adjudication.
I looked at the Calhoun and I can't remember if it was,
So battery in 16 that was dismissed, Mr. Gill, the ones he's on probation for now, which happened after this one. And then before that was an old charge of possession of alcoholic beverages by a minor. What's the state's position on adjudication on the battery? I know that can have certain adverse effects later on.
given that it can be enhanced, it doesn't matter. State takes no position if there's a.
The state's not asking for it to be adjudicated. That's about what you're about to say too, right, Mr. McDaniel?
And I was going to say also that I know that she has contacted me, the victim and the state after all this incident when we dropped the charges. So, I mean,
That's what I'm saying.
take those into consideration as well.
So I'm going to withhold adjudication of guilt then, sentence you to 30 days in jail, impose the standard court costs and fines for that charge, which are $722, and give you credit for how many days, Mr. McDaniel? 4 days credit, Mr. Bunting. And Mr. Bunting, you'll get a chance to work that off at the jail, those court costs and fines. If you don't get them worked off, there'll be a civil judgment against you. And Mr. Bunting, this resolves this case, and this doesn't violate your probation because this charge allegedly happened before the charge happened. The event allegedly occurred before you even on probation. Let me see if your father has any questions first. Sir, do you have any questions?
From what I understand, he's got to do another 30 years.
He has to do another 26 days at most. The reason I say at most is Florida law allows for gain time in most cases. So by following jail rules, he could do as low as 22, 20, maybe even 20 days, but he'll do somewhere between that number and 26.
He has a $722 fine.
He's got battery carries a $722 fine under Florida law. If he pays it or works it off, he may have enough time to get it worked off at the jail. He won't owe anything if he gets it worked off. And by getting in the trustee program. If he doesn't get it worked off, he has to pay it, or by law, the clerk's office will send a notice to the state of Florida and his driver's license will be suspended after about 90 days. And that 90 days doesn't even begin until he gets out of jail. You can see, anyway, you can see Mr. Bunting. I have no control over that. You may want to call Chief Jeter at the jail, and they may or may not let you, since under the circumstances, that's his call. Okay? Yes, sir. Mr. Bunting, do you have any questions?
No, sir.
All right, sir. Wish you the best. Thank y'all for coming. The next defendant that has friends or family here is Rusty Tucker. Mr. Tucker, you have several family members in the courtroom, sir. You're here because you've been accused of violating the terms of your state probation. I have a copy of a warrant signed by Judge Garcia that has no bond on it. So what you've got is a no bond warrant. What we're going to do this morning is I'm going to arraign you, which means I want to get you a lawyer appointed if you're asking for one, so we can give you a court date, and we'll see if you have any questions in just a moment. Would you like to have an attorney appointed to represent you, Mr. Tucker?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then we'll see where we go from here.
Your Honor, I spoke to Mr. Tucker. We're going to plead not guilty to the charges. Get him on arraignment docket for April 23rd, and I advised him there'd be an attorney that would visit him prior to that court hearing.
April 23rd. So, Mr. Tucker, that'll be your court date. An attorney will see you before your court date. But right now, that's Judge Garcia's next VOP date. I did tell you you've got friends or family in the courtroom. Mr. Tucker, do you have any questions?
Yes, sir. I'm employed.
You want to let your family know to go talk to the attorney. You're not asking. He wants to say he's employed. He wants to be out. He's not getting out already.
Yeah.
He wants to let his family know that if they go over there and talk to Guy Green's office, if he can't get on the docket, if they can't work something out prior because he's got a job and he don't want to lose his job. That's what he wants. But that's what you want to say, Mr. Tucker?
Yes, sir.
Okay.
So, Mr. Tucker, your family's already tried to explain to myself and the state a little bit. We didn't get into much detail at all because Mr. McDaniel wasn't here. I just explained to them that it's Judge Garcia's warrant. It's her case. Sir. I'm not involving myself in another judge's case without permission. So you got to deal with Judge Garcia on this. It's her warrant, her no bond warrant. Okay?
Yes, sir.
All right. Wish you the best, sir. Does the family have any questions? Guy Green will be his attorney, but Mr. Green won't even know he's been appointed yet. So you may want to wait till the first of the week or even the middle of the week. Talked to who yesterday? Okay. Well, then if you've already talked to him, then he would be the attorney representing Mr. Tucker, and he would be the one to go to the jail and talk to Mr. Tucker, or sometimes Mr. Sims or Mr. Blunt will do that along with Mr. Green. Okay. All right. Wish you the best, Mr. Tucker.
All right. Thank you.
Yes, sir. Thank y'all for coming. All right, Mr. McDaniel, that's it for friends or family. So let me go back to the next case on the docket, which appears to be Shannon Kent. Kent, you're here because you've been accused of 1 count of driving while licensed, suspended or revoked habitual, and 1 count of tag attached, not assigned. Mr. Kent, I'm the judge that signed the warrant, and I think I missed something. I don't think the warrant alleges that you were a habitual offender. The complaint doesn't. But I went back and I looked at your driving record, and you clearly are, according to your driving record. But normally that does have to be in the complaint, and I just think I missed that. So I found probable cause when I signed the warrant for these charges. I'm going to adjust the bond accordingly because there's actually probable cause for a misdemeanor offense in the complaint. The state may charge you with a felony based on your driving record. It appears you may qualify, but what's in the complaint is only a misdemeanor. Mr. McDaniel, anything on behalf of Mr. Kent?
No, Your Honor.
Mr. Gill?
Nothing on behalf of the state, Your Honor.
Mr. Kent, I'm going to set your bond at $2,500 in each of these cases. That's based on what's in the complaint. Your bond is $5,000 cash or surety. You have a condition not to drive a motor vehicle without a license. If you get your driving issues straightened out, you drive as long as you want. Your license issues straightened out. But unless if you get caught driving and you still don't have a suspended license or you still don't have a valid license, that will violate your bond. Mr. Kent, you will get to use the phone in a few minutes, sir, to try to post the bond. I'm going to ask the jail to give you a notice for your court date, sir. That court date will be April the 7th at 8:30 will be your court date in circuit court. Mr. Kent, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
The next case we have is Kirk Hagen. Mr. Hagen, good morning. Mr. Hagen, you're here for first appearance accused of one count of battery. Mr. Hagen, there is probable cause for the charge. I'm appointing the public defender's officer to represent you, and then I'm going to listen to the attorneys. Mr. McDaniel.
Your Honor, Mr. Hagen, he's disabled. He's currently getting disability check from the government. I think it's been over 10 years since he's been convicted of a crime. I mean, he obviously has some defenses on this charge, Your Honor. We'd ask the court for some kind of reasonable bond.
Mr. Gill.
Judge, the allegations are this argument started over alcohol. It does involve a cane, and the allegations are that the victim was hit and struck with a cane. That could be charged as aggravated battery. Judge, we are asking that he get a high misdemeanor bond and that he have no contact with the alleged victim. And state is also requesting that he not be able to possess or consume alcohol during, if he's able to make bond.
What about I remember having him in a 2024 battery with somewhat similar allegations. He was supposed in a wheelchair then at times also, but I think that case may have been dismissed. It looks like it was dismissed. So I think Mr. McDaniel may be right. He said his last conviction was over 10 years ago. He's been arrested as recently as less than 2 years ago, but it was dismissed.
I skimmed his CCIS, Judge. I think that's accurate.
Okay. So Mr. Hagen, given that information, sir, I do remember the prior case, and what I'm gonna do is set your bond at $3,500 cash or surety. You have a condition of no contact with the alleged victim. No contact at all, Mr. Hagen, and I'm not likely to modify that condition based upon these allegations. So if you post bond, you have to go somewhere else. If you have belongings in her residence or where she lives, I have no idea whose name the lease is in, or if there's a lease, or if there's ownership or whatever, but if that person doesn't live there, if they're legally removed, you can certainly go there. Otherwise, you have to go somewhere else. Your bond's $3,500. Mr. Gill, at this early stage, do you want him to give a notice for the misdemeanor court date or the
Yeah, that's
felony?
fine, Judge. You can get him, yeah.
Okay, so we'll give him notice for his misdemeanor court dates, please, corporal or lieutenant, and that would be March the 30th at 9 a.m. will be your court date, Mr. Hagen. March 30th at 9 a.m. Do you have any questions, sir? All right, Mr. Hagen, wish you the best, sir. We have Alan Davis next. Mr. Davis, good morning. Mr. Davis, you here for first appearance on good morning. You're here on a charge of no valid driver's license from 2024. Mr. Davis, I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Yes, sir. Your Honor, I spoke to Mr. Davis. At this point in time, he's going to plead no contest to charges listed. Your understanding, he'll be sentenced to 60 days in the county jail, 2 days jail credit. He signed his waiver, waived his right to jury trial and call witnesses. $400 fine. This will resolve this case today.
Thank you, Mr. McDaniel. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
And Mr. Davis, did you hear that agreement? Mr. Davis, did you hear that agreement?
Yes, sir.
Mr. Davis, is that the plea that you would like to enter?
Yes, sir.
Mr. Davis, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license. I'm going to judge you guilty of that misdemeanor or criminal traffic. I'm going to sentence you to 60 days in jail. You've got credit for 2 days you've already served, $400 court costs and fines. Mr. Davis, there's no probation involved in this sentence. It's a straight jail time sentence. What that means is when you finish the sentence, sir, you will be completed the case. Mr. Davis, I would encourage you to talk to the jail staff about the trustee program because that may get you quite a bit of extra gain time. Mr. Davis, do you have any questions, sir?
No, sir. Thank you, sir.
Wish you the best, Mr. Davis.
Yes, sir. Good luck to you.
Great.
We have Gregory Alday next. Mr. Alday, good morning. Mr. Alday, you're here for first appearance accused of one count of driving while license suspended or revoked knowingly. Mr. Alday, there is probable cause in the complaint, and I've also looked at your criminal history. I'm going to appoint the public defender's officer to represent you, Mr. Alday. I'm going to ask that you listen to Mr. McDaniel, please.
Your Honor, I talked to Mr. Alday. We're going to enter a plea of no contest to charges listed. Your understanding, 30 days in the county jail, 1 day jail credit, $400 fine. He has signed his plea waiver form, waived his right to a jury trial and call witnesses. This will resolve this case today, Your Honor.
Thank you. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
Mr. Alday, did you hear that agreement?
Yes, sir.
Is that the plea you would like to enter, Mr. Alday?
Yes, that's the plea I am.
Mr. Alday, I'm going to accept that plea of no contest then to the charge of driving while license suspended or revoked knowingly. The judge, you're guilty of that offense, sentence you to 30 days in jail. Give you credit for the time you've served, which is 1 day, impose the standard court costs and fines of $400. Mr. Alday, you also may or may not get some extra gain time under Florida law. I would encourage you to talk to the jail about that. And hopefully you get out there a little bit earlier and put this all behind you. There's no probation involved in this sentence. Mr. Alday, any questions?
No, no, sir.
Wish you the best, Mr. Alday.
Thank you.
Mr. McDaniel, that's it on my list. Anybody I may have missed, sir?
No, that's everything.
And anything else from the public defender's office?
No, Your Honor.
Thank you. Mr. Gill, anything else from the state?
Nothing further, Judge.
And Lieutenant, anything else from the jail?
No, sir, that's it.
We appreciate it.
And that is the end of that day, but our day continues. Good morning once again, everybody. TCF Live. Happy Super Friday to you. Let's go to Fulton County, Georgia. This is Judge Rochelle. Is it Carnesale or Carnesali? If you know in the chat, tell me, because I don't. I could see it either way, but let's go there.
Coney County Jail. He's amassed a number of certificates. Like, he's used this time to his benefit greatly. He has substance abuse, a basic math, prayer interest, another substance abuse, harm reduction, formulas for career success, celebrate recovery, parenting while incarcerated. These are all certificates. It's 9, I believe, in total, that was provided to me by Mr. Neal's wife. He does deny the allegations of the new charges. He was driving and had a passenger in his vehicle who later admitted to being in possession of the substances that were found and located in the vehicle. However, Mr. Neal had already been charged at that point. He is willing, if he's given the opportunity to be reinstated, to go and attend Narcotics Anonymous. He currently works at Hunter's Remodeling LLC with his son, which has been incorporated for about 5 years, but he is in construction and does remodeling by trade. He's done that for the past 20 years. He's currently at risk of losing his home, and so he desperately wants to get back home so that he can get back to work and support his household where he and his wife are living. He states that in regards to his arrears, he can pay his full arrears within a month if he is released. If Your Honor is not so inclined to reinstate his probation, we would ask for 3 months revocation, a 90-day revocation, and we with hopes that he would be allowed to serve his time in the county.
Okay. Ms. Mondava?
Judge, I'm fine with that.
Okay. And Ms. Officer Julius?
Yes, Your Honor. In lieu of what he has been doing since he has been there, I hope he stays on that track, and we're fine with that.
Okay. Nothing ventured, nothing gained. You talked your way into a get out of jail revocation today. All right. So how many days has he served?
Yes, sir. 37 days.
Okay. So we'll make it revoke 37, reinstate. Is that okay, Officer Julius?
I'm sorry, I thought we were going to do 90 and giving credit.
That's what I thought.
Oh, okay. Oh, you guys were agreeing with that. All right. They asked for get out of jail and the alternative 90 days. So you're asking for 90 days?
I thought Miss Will said 90 days. I apologize.
That's okay. That's okay.
Sorry if I wasn't clear. If Your Honor is so inclined to reinstate, if everyone else is in agreement, that would be my ask. But I was saying if that is not possible, 90 days so that he can serve that in the county jail.
I'll split the baby and say 60 days. So a little more time, and then he'll be out. So it's almost get out of jail.
Thank you.
Okay. All right. So I'll find that you're stipulating to a preponderance of the evidence that the state could prove the allegations in the petition for purposes of this hearing. And we're going to revoke 60 days and then reinstate. It's so important that you stay on the track that you're on. The reason these two ladies agreed to 90 days is because you're doing really well. And I don't think I've had somebody else up here who's done all that in that short a time. So good for you.
Thank you.
Yeah.
And also do I get time served with the?
Yes, you get credit for time served.
Thank you, ma'am. Thank you.
All right, that's it for that one. So you can go now. Thank you. Oh, do you need to meet with him, Officer Julius? Or
No,
do you-
Your Honor, I met with him already, so he could be done.
Okay.
Finished.
Thank you. Okay, who do you guys want to take next?
Judge, the jail is asking if we can handle South Annex.
Okay, who do we have in South Annex?
Mr. Walls, and I am ready to proceed with Mr. Walls.
Okay, do you want to present that one?
Sure. So the current recommendation is 9 months. So Mr. Walls, he does have new charges. However, he does adamantly deny those new charges.
Are they
He
also domestic violence charges?
Yes, Judge.
Okay.
I did ask who called the police. He's not aware. There was a bond hearing where he stated the alleged victim did appear and she denied the allegations and the incident even occurring. Again, he doesn't know, and he states that she does not know who called the police. But again, he adamantly does deny those allegations. He has registered for the Family Violence Intervention Program. He states that his niece has documentation of that. I'm not sure if she's on the call. I have not had the opportunity to speak with his niece, but he stated that he has registered into that program. I would request 120 days revocation. We do understand that these are charges of the same nature of the underlying charge, but he was granted a bond, and he states that in part, that was due to the alleged victim's testimony at his bond hearing is what led to that decision.
Do we know if it's the same victim in the original case and the new case? Or alleged victim, I'll say.
Give me a second, Judge. I'm trying to look that up.
So I'm just wondering if he violated, if the allegation violates a or a probation condition of the original probation too.
I'm looking at it right now. Give me 1 minute.
All right, friends, we're a couple minutes in the way back machine. Let me see if I can bump us past this dead air.
Froze again, by the way.
There we go.
I think you're fine because we can
Guess
see.
I'm
We can
supposed
hear
to be
you in real
frozen.
time.
I don't know what's going on.
It's okay unless someone has an objection. We can see her and we
I'm
can
having
certainly recognize her
use
voice.
my husband's computer for the Zoom and my computer because my webcam isn't working.
I think you're fine
So.
because we can see you and we all recognize your voice. Any objections to this? The way, okay.
No objection. I don't know if this will help. I'm trying to pull up my information, but it says Tasha Donaldson is listed on the petition as the no contact. So I'm not sure if you're in the new case looking.
Oh, okay.
Everyone's
But that's the name that's noted on the petition.
The new case has Tasha Terrion Durham. Is that who you have, Kaylee?
Tasha Donaldson.
I have an incident report with. Is that not the right incident report?
It's got to be the same Tasha, unless there's a new Tasha.
Mine says Tyrion.
Tasha Tyrion?
No, Tyrion Durham is the new case.
Oh, okay. So that sounds like a different person.
And then the old case, I have Mr. Banks' sister, and then they said an unknown victim that's her, his significant other.
Okay.
So I'm trying to figure out if I have a case number, a victim name for that.
Okay. Well, let me ask this. Officer Julius, what's your recommendation on that case?
Your Honor, since he has had 3 previous convictions for violent offenses, it is 9 months and reinstate.
Okay.
I'm under the same impression, Judge.
Okay. And tell me again what you're asking for, Ms. Wells.
120 days.
And you said, I'm sorry, you said he has 4 total violent offenses, Officer Julius?
Yes, Your Honor.
Okay. And the new arrest, is that a misdemeanor arrest or a felony arrest?
I believe it's a misdemeanor. Give me 1 second.
I think it's actually a felony.
It is a felony. It is aggravated assault, a felony. I'm sorry.
And the new case number is 26 SC 0000637.
Okay, my inclination with the information we have today is to go with the state's recommendation. But Ms. Wills, if you want to set this up for a formal hearing at a later date, that's fine. If you want more information on it.
Okay, I will confer with Mr. Walls about that.
Okay. Do you want to jump into a breakout with him right now?
Sure. Yes, I will do that.
We'll put you in there. Is he going to be the only one we have in South Annex, Atina? Okay.
Yes.
Yeah, let's go ahead and deal with it because they're eager. South Annex is asking us to finish.
Okay, friends, let's change it up. Let's take a minute and go into the Wayback Machine. So we were watching that trial in Judge Oakley's court yesterday. Let's take a few minutes now, go back to that, and catch the closing arguments.
When closings.
Oh, when we started, I gave you that checklist, what we're looking for, what we're looking for. So, remember, revisit that again. Testimony that on May 18th, 2025, and the city of Huron, or Huron, that this defendant, Maggie Beckman, appeared at 22046 Cecile Drive in Wayne County, and she made contact with Caleb. Now, with her testimony about her coming in, she admitted herself coming in. She wanted a confrontation. She wanted to get what was over. She wanted she was upset about the situation. And, that for herself, I regretted that. There's probably a lot of things that she regretted. Now, we heard testimony, she went there, she had a look at the address, maybe she found out her tattoo was covered. Her name, Dawn. That's her partner. And he's saying, not you. She was upset. She went over there. We've heard that she barged her way in. We heard a slap sound. 2 witnesses described the same sound. Here to figure out whether violence happened or whether it's domestic. But 2 things. One is that body. Weird testimony. I regretted going over there. I regretted. I was angry. I was upset. She didn't say she was. I was upset. I went over there. I wanted a confrontation. I wanted to contact Amanda. I went. She was upset. And she paused class. Second unit prove that you protect one that they were in a relationship. Check. You heard, I know there was only one eyewitness having the victim, but there was also an auditory witness. Now, normally it's nice to compare what two people see, but I think it's also equally as nice we have 5 senses. Let's use all 5. So she was consistent about those conversations that were being had. She was consistent about the noises that were heard. And she was consistent about, yes, I called her. Yes, Gail called her. Consistency. There's consistency to, about one second. There was consistency to, about time that this happened, the order of events, hearing the door open, hearing that of that counter. There was consistency in the slap. Now there wasn't consistency as to the amount. But as you remember, Caleb didn't really provide too much details of the second one, but we do have a lot of details on that. Understand? Slap that spot where the tattoo was. Then they had to go back and get that. Now, we heard about the banging at the door. We heard about her coming closer to the door. And we have 2 testimonies, and her testimony, actually 3 witnesses testified that after she came in, one, that confrontation, she was brought out. And we heard the door close, we heard the glass break, we saw the burning. We had auditory cues about how this went down. Now, before we talked, in the beginning, we talked about credibility, right? That this is a he said, she said, right? And we talked about how we determine credibility. We're looking for, not only just their stories, but some of those visual cues, some of those, perceptive cues that we have to determine some of this stuff is true. I need to really go back and listen to the judge's instructions about witness credibility, as well as compare that to what we saw. I don't think any of our witnesses, frankly, were really combative. I don't think that anyone was combative. I don't think that anyone was showing signs of discretion. That's for you to defend. However, when we think about the defendant's statement, they're also very telling. She was upset. She went there angry and ignored them. She at first waited for the police, but then when the police arrived, didn't, drove away, didn't flag down an officer, kept going, and then once the officer stopped her, she was up, and she had her shit. Now, we went through our checklist, and now I'm asking you that you see that we have not heard, we have proved beyond a reasonable doubt that these 2 people were in a domestic relationship and that violence occurred. At this date, this time, and this station. But this time, I'm going to ask that you find the defendant guilty. Thank you.
Mr. Hadley.
Thank you, ladies and gentlemen, for sticking with us. And you guys probably did you great today. We got to go in. So I'm going to try to keep this quick, but I also I can't pass an opportunity to like advocate for my client after what we've heard. I've got to connect to the games. I know you guys can do it, but I wouldn't be doing my job if I didn't let it. So I agree. We talked a lot today before you got started about credibility of cases. I understand that there was emotion involved by all parties in this. But what we heard today, for outside the police witness, everyone who had a little skin in it, my client, her ex-fiance, his fiance. And you guys are also the witness today, something you don't see very often, which we actually had a witness who had testified previously under oath and actually admitted today that whatever he said previously under oath wasn't true. Don't get that moment quite often, but it did happen today. Does that mean that everything the guy said is just a full blown lie? No, I'm not saying. But when we were talking earlier about what are we really talking when it's just two people's words against each other, what do we go to? How do we make the quote tiebreaker when we're not benefited with that evidence? But we all of us would love to see it show me proof. We all feel better if we have it. Never gonna get that these things. Really, in most of these cases where there's not going to be that security cam at the 7-Eleven that shows the 6'1" suspect leaving at 11:59. There's going to be parts of this that fall on you guys. And that's all I'm going to do right now is just kind of point out a few of these kind of moments that we all heard today together. I apologize if I reacted with looks on my face. Sometimes I've been warned by judges not that often. But there were a couple moments today where I just was a little beside us. We had an alleged victim. I was going to call it what it was. You guys assume. He's a really good dude. He's really making sense. I'm with my client. If you really parse together the parts of his statement that did stay consistent, it was that he had posted himself up in a partially open door. Wants us all to believe that she somehow or another barreled through said or did not get the guy that you saw her on the counter behind. You heard the officer testify the place didn't look like it was in disarray or things have been flipped over. Get shoved backwards by her, and there's really nothing to look at. So remember we talked about absence of evidence before as well. Seems a little weird. Doesn't mean that it couldn't happen, but that starts to go into the weird category. Doesn't look like anything strange happening here. Caleb that night, this happened back in the 18th. He was questioned multiple times. Every time he was questioned, we even got to fight on today. I think we got the right answer. We made this consistent. So never before today did anyone heard this mystery second slap. That was another one of those moments from what? So somehow or another, between the dates that this happened in 2025 and now, not the story ain't consistent, it's grown. A new allegation of another assault. Okay, let's just keep moving from that. That seems strange, right? Seems like right after what had been happening would have been the time we told the officer they got smacked multiple times. And let's just talk real quick about that. We've got that in-ear witness. And I thought that some of her testimony was fairly credible today. In fact, when she finally was pushed with the facts that you really didn't see or know anything. In fact, it's even possible that Caleb could have slapped my client. She stopped fighting. You know what I mean? We did see that at a certain point. She did admit that, oh, okay, you know what? I was really relying upon this. Someone, it's not back to my main state. I went with what he said, and I did tell the officer that I saw or I may have more information, but she backed off. Today just kind of kept wiggling. I still feel like we just would have been further confused. I could have probably continued to re-ask the questions and get different answers, but what that tells me from years of doing this and just having kind of that spidey sense of does it sniff past the sniff test, that none of that felt right. It certainly seems like this individual believes there's a right answer, there's a right set of words, a right set of things that he can string together that are still not going to change his overall life situation as it relates to their client, their child, and common. Today was a little bit confusing because you're hearing about a family court case. You don't really know what happened because with rules of law working rules of evidence, you can't fully get into that, nor is it appropriate. But what you do know is this is a really big picture that's been going on for a really long time. You never heard at any point today, Caleb, in the 4 years they were together, never make any accusations that she's previously been violent. Even if she's an aggressive person, even if she's an angry person, other than she hurt this study. So that kind of makes you, again, go back into what's really going on here. Well, what we do know from Caleb's testimony, we finally PC'd some facts there, is that even though there's been this alleged assault that happened at his new fiance's house, he seemed to be really fixated on how to get a PPO and how to get family court paperwork filed. Really, I think I don't have to lean too heavy on this. I firmly believe that all of you guys, I just had to pull those dots close enough for you guys to say, yeah, that connects. And it does. When I talk about loyal to lie, it's a big jump. Telling somebody, accusing somebody, saying, I don't think you're telling the truth. So you gotta be really careful about throwing those types of accusations around. In this instance, I any reservations whatsoever. If I had them, they're gone after today. Again, when somebody can look me in the face and just continue to not really commit to what happened. And we're not talking about a 9-part pile of 13 different witnesses. This is really simple. Your emotion kind of clouding your objective judgment really should be the only thing that would cause a difference in your story, right? But no, the story's grown. The story's changed. 1 slap, 2 slaps, plates breaking. Originally, the officers came out the moment that this all happened. They got to the story. My suspicion would be it was broken, turned light, throwing Mayor out the door. She can't even say that's exactly what happened. We know from this inconsistent testimony, this timeline, that that's really what it started to sound like today. That was back to Caleb himself admitting that the preliminary examination, he was asked if she'd break the lights. No. Today it changed. So the police, she went out, unscrewed it, and whipped it at the house. Preliminary didn't happen. Today it's a new version. 3 separate stories about someone that's how consequential really is it what we're talking about. They have to prove she touched Caleb and that they were in a relationship previous. Nobody's talking that. In fact, you've heard from everyone in a relationship. It's like with the touching. You heard Hagen that she put her hands on Caleb. You're going to get a jury instruction here in a moment about self-defense. Somebody's grabbing you. You don't have to kill going right along. You absolutely have the right to assert a reasonable proportionate get off of that. As long as you don't escalate their civil force. You have to be stronger than the person getting first. You win that one, that's on that. She didn't do anything like that. She just simply was trying to get herself free from them. And if you see the video, I apologize, it takes on a big thing up. I know you guys know what the skin and knee looks like, but there's a lot of testimony made about police didn't think that other people, why did they do that? She's tall with her unplaying eyes, and she showed the officer, she was bleeding, she said, blood run down me. Clearly it just, we saw a picture of the broken glass all over the patio area where the complainant himself admits that fire hurt her. You connect her statement that she got her up off her feet, slammed on her. Bleeding. She stayed. She's being told police are coming. One part of her brain, I think it's nice and put yourself in her shoes. I'm not saying that. It's just I think we'd all have to relate to a haywire kind of situation where the person whose porch you're standing on saying you must leave, get out of it. On the other hand, they're saying I saw the police, and you're saying, well, I don't have to be heard by them saying police. To somehow make a responsibility or onus back onto her for not seeing a random police officer at the front of the park and not going up and flagging him down. I don't think anyone's here is going to be distracted. I think we all know what happened. Saw the video, saw her cooperate, and most importantly, you heard her today testify. Incredible. There weren't crocodile tears up here today. There wasn't a big production. That I truly have admiration for my client. It's come off today. I think that she's a very strong person. And if all of you that had watched all of the videos, all of it strung together, see her handle the aftermath of this and talking to the police about it and keeping her story straight, it's not hard to do. And that's why, even in an emotional state, her story didn't. And that's why today, even under cross-examination from the prosecutor, did a good job of covering some questions. Story bitch. But here we go. In the end of the day, he's going to talk after I'm done. Put my head around it. I'm going to say anything else after this. It's your job. Putting this in your hands at this point in time. The prosecution must prove to you beyond reasonable doubt. No, it's got to be beyond that. Well, the judge is going to tell you what the law is, but I mean, at the end of the day, I think some slight lawyer made this. I'm a big fan. This is a demonstrative I'm about to show you. What that means is this is not evidence. Okay? I'm just showing you. Maybe. A little chart that those regular criminals. This isn't the law. It's just something that kind of helps me understand. People are talking, we're trying to use the legal language. I know that's really small.
If you want a poly comment, we can poly comment. Josh, we can poly comment so it goes there.
I think everyone can see that too. They're not even big dirty. Again, this isn't the law. This is just kind of like a little clever, like, hey, let's look at this. So as you finally start kind of coming through these scenarios, you guys are going to talk about this when you go back there. What about this? Well, what about this? Why don't we get that? It was slack, but there's no picture of and no evidence in it. Some of these missing things. So after going through all that, you may come up with a whole bunch of different scenarios, like hypotheticals of what may have actually gone down. None of us will actually know, only people who were there. But I think all of us can put together facts together, what we think logically or reasonably happen. Perhaps suspected, guilt likely, a whole bunch of stops and training until you get up to that top level, which, as we said before, there's a reason that hurt me so high. Yes, I absolutely am. I think I'm just making an echo. All right. So my little clever demonstrative. Prosecution's gonna get there and point at it and spin it like a good lawyer does and show you why it works in this case. You've got a lot of room on that. You guys were asked at the beginning of this today, and it's when we got to the end. If you'd be able to make a decision based on just testimony alone, if you want to see something more, always want to see something more. And thankfully today, you guys did get testimony. You got inconsistent testimony, you got inconsistent testimony. We got some pictures that show what actually happened. She saw some evidence of what was actually there. Plaintiff has a tremendous amount of motive. There's a lot in his mind to gain right now from inflicting pain on the as the investigation are here. Try to make it make sense. Just remember. I thank you all sincerely for your time, patience, and keeping an open mind through this process. I do firmly believe today, prosecution not their fault, but the facts are the facts. They just don't have.
Mr. Licky.
So the reason why it's hard to stay out because the prosecutor, we see him all the time. Here's my problem. There's one bar that's always high, right? We're gonna see reasonable doubt. Now, above that is unreasonable doubt of all doubt. That is about my problem. I had it every single. This child case. I don't have to prove that she's a psycho. All I have to prove is that this defendant got into that house, assaulted, meaning threatened, or you can take it down, sir. I'm so sorry. We're good. So all I have to prove is that this individual assaulted, either got into that house, threatened use of force on Caleb, or she battered it, actually made contact, assaulted him without, and touched him without his consent. Now, counsel brought up those self-defense jury instructions, and you'll have those as well. I want to read the last paragraph. So, Judge will read all these, just take the last paragraph. They're all important for the last paragraph I think applies to this case. 4. The person claiming self-defense must have not acted wrongfully and brought on the assault. However, if defendant used only words, that does not prevent her from claiming self-defense if she was attacked. This individual went to this house, didn't stay in the threshold of the doorway, forced herself in, pushed herself in as the testimony reflects, and then assaulted our victim. This is what testimony would be. Now, even if we were to take a slice of it, no, she didn't bar her way in, she didn't push her way in. But she took advantage of that space. She took advantage and then moved closer to where her rival for her ex-boyfriend was at. Those are facts that all of these parties agree to. Now, granted, she didn't grant, so granted, they could have orders. She could have pushed him over the counter could have been a mess, could have broken off. We could have had all those things go. But judge is also going to instruct you that injury is honest. I don't have to prove that he's injured. I don't have to prove that his tattoo burst or that film that wraps it burst and it was injured or that was red. I don't have to prove injury. Which prove that is. Now, I also want to talk about what Council said. This isn't about, right? And, I think it's very responsible and appropriate that the defense counsel has admitted that. That's not my review. Because we're here for one date, one time, one effect. Now, that family court case, yeah, it might play a role in some of their motivation. Don't see that. But if you're Caleb, what's going through you're surprised that this individual, who's the mother of your children, arrives to this house, acts in the way that she acts. And now all of a sudden you're supposed to be comfortable that your daughter's in the presence of that. And we're supposed to be surprised that that is going through his head when he's talks to the police. Now, I can't vouch for him. I can't vouch for his credibility. That is your job. Keep that in mind. Yeah, his first thought was on a mistake. His mother of the kid who has custody of the kid just acted in a way he was not prepared for, suspected, and put him in a little bit of fear. When you heard that, he's a big guy. For him to be afraid, he's well afraid. He said that to me. And she was afraid. And the sentence, all I have to prove is that an assault and or assault there. That he was afraid an injury was going to come to him, or an injury didn't befall him. This isn't a family violence, domestic violence. Now, when we look at some of his testimony, I understand some of it can be inconsistent, and some of it maybe hasn't been heard, but that's for you. But he answered, he doesn't know how to look. He doesn't know and didn't have the opportunity to conduct a 3-hour interview with police that we put him through here. And neither did Miss Atkins. So not only do you have to consider how the witness testifying to you, what their statements were prior and what their statements are today, that will instruct you with that. But they'll also instruct you to their conditions, like we talked about, maybe it's nervous, maybe it's this, that, and the other. But I would also urge you to consider those prior statements as well. What was their state of mind? What was their mental states? What are we doing when those statements are? How much time do we? The time plays a role. We talked about here, some of us have pretty atypical careers, or as teachers, we work in different fields and have different kinds of students that we work, where everyone's response to interactions to stressors differently, and what we through in our career. I just want to ask you to keep all of that. And I think at the end of the day, you will see that I proven install and or install that in place. That this defendant is the one who did it at that date, that time, that location.
All right. I think that means we're ready for me to read to you again. So you can follow.
Okay, friends, we're going to skip the reading because it's just standard jury instructions, nothing too spectacular there. So again, those were the closing arguments for the trial that we watched yesterday. I'm also going to give you the verdict right now. So they were recessed for a couple of hours while the jury deliberated, and the verdict, they brought in the jury. He said, "What's your verdict?" They gave it. And then that was that. It was like 30 seconds, so it's nothing overly worth showing because it's not dramatic from that standpoint. But it was not guilty. She was found not guilty. And then he got the stream. So that was that, a not guilty verdict. So I told you we'd finish it off, and we just did. Okie dokie, let's go to Texas Judge Stevens.
Okay. You are Romero Williams, correct? Seeker. Here in cause number 23, CR 1039. Mr. Burbank is here representing you, and the state's attorney is present. Earlier, you entered a plea guilty here to the 3rd-degree felony of illegal possession of a firearm by a convicted felon. Pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it? The state of Texas.
We've reviewed it. No objections or changes.
Mr. Burbank, on behalf of defense. All right, it's made a part of the record for all purposes. The agreement here is a cap. Whatever sentence shall not exceed a cap of 5 years in prison. So we are looking at no less than 2 nor more than 5 years confinement in prison. The defendant could be placed on deferred or unadjudicated probation and could be placed on regular probation as well. Okay. State, you can go first and last if you wish.
Judge, there's a couple of things that jump out to me on this. Number one is to his benefit, he hasn't had any felony cases since 2008. The problem is that he really did his best to minimize
where he's got this one, right?
Yes, sir. Yes, sir. And clear, you know, his track history of handling probation is poor, in which the probation office points out. And by that, I mean, he's been given a chance of probation before. Both all attempts at that has failed and resulted in him being revoked.
On 2 separate occasions.
Yes, sir. When you look at his, the PSI, and when you look at the version that the officers give at the time in which the incident occurs, Mr. Williams blames the guns on being his brother's. When he's later interviewed by the probation office, he says they weren't his, they were friends. So, I mean, we've got an inconsistency from the very beginning, and it's all about his attempts to minimize the situation here. And I know what they're going to argue for is probation. And I don't believe in giving probation to people who don't accept full responsibility for the actions in which they're there. I also don't think probation is the right situation here because of a lengthy criminal history that this man has, even though it's been years since he's had a felony offense, and because of the additional factor that he's never succeeded with that in the past. I would ask for the 5-year sentence, Judge.
Okay, Mr. Burbank, on the behalf of the defense, go ahead.
Your Honor, thank you. As always, or most of the time, Your Honor, I look at it differently than Mr. Ham. I believe he did take responsibility when he was stopped. He was the one that told the police officers that in the trunk, not under a seat, not on his person, not in the glove compartment, that there were 2 firearms in there and they were packed away and they were not loaded. And if I had a brother, I would probably consider him my friend. Or if I had a friend that was a brother, it would be vice versa. But he was very forthcoming with the police officer and cooperative. The last time that he had anything was back in 2007 and 2008. No, with probation, it was state jail. He was revoked, but that's when he was a younger man. He's 43 years old, 44 years old. And he was a younger man back then. But since then, he has not been convicted. This is his first felony, TDC felony, and out of state jail. During this time, though, Judge, he is employed full time. He keeps a household. In fact, he does work for some law enforcement people still. So I guess he's trusted in what he does. And so we would ask, Judge, that you would consider probation. Of course, this court puts them on 6 years, 10 years usually. And if they do well, then they could be let off early. I think he's an appropriate candidate, even though with his past history, many of the allegations that Mr. Ham has alluded to were either rejected or dismissed and have no idea why back in 18 and 14. The last time he was convicted was in 2008. So it is some time. I would ask that you would consider probation, except for the criminal conviction, regular probation, Judge, there is no punishment enhancement on deferred. What I mean by that is if there was a second or a first, there'd be more time over his head. But there isn't. And if you have any questions, my client.
Anything you want to say?
Yes, sir. I don't get into too much trouble.
I'm sorry?
I don't get into too much trouble. I take care of an 85-year-old woman. That's my girl. She's in the wheelchair. She's on oxygen. That's where I stay at. I work for Tyler Ward. I worked for 4 years. I work right across the street from a police station. I'm always at working at home. That's the only place that I can be. If I was granted probation, I would do good on it because I do have a job I do not.
You've been in trouble.
I've been in trouble, but I don't get in trouble. That was when I was younger.
How many convictions do you have?
I have
That you know of? Yeah.
One day I went to state jail. Just one day I went to state jail for 2000. I think I stepped on.
Is that your final answer on that one?
That's not.
Okay. Well, let me point out a couple of things that you apparently don't remember about your own life. Let's see. You were arrested in 2007 on illegal possession of controlled substance and placed on 2 years probation for state jail. Let's see, 2 years state jail, probated for 4 years. And that was on January 17th of 08 and a $500 fine. That was revoked about a year later, and you were sentenced to 1 year in the state jail. Do you recall that?
State jail.
Then, let's see, there was a 2000 offense that was 2 months after, filed 2 months after the original illegal possession of a controlled substance. It was called abandoning, endangering a child. And you were placed on 2 years, sentenced to 2 years state jail and 4 years probation on that same day as the illegal possession of controlled substance. And it was also revoked on April 9th, and you were sentenced to 1 year in state jail. So that's 2. conviction. And to round out the field, in 2008, apparently you were charged again with manufacturing and delivery of a controlled substance and sentenced on April 14th of 2009 to 1 year in the state jail. Correct? That's 3. You had a little trouble with your math on your personal life, but you got 3 felony convictions. How many misdemeanor convictions do you have? Let's see if you can guess correctly. It's your life. Nobody knows more than you. Don't look over there. Do you have to have help on how many times you've been convicted? You have to have help on that? You've been convicted of illegal possession of marijuana in 2005, and loss of carrying a weapon in 08, criminal trespassing in 08, assault causing bodily injury of a family member in 2013. That's 4 misdemeanors and 3 felonies. That's a total of 7. Wow.
Right.
Okay. We're a little unclear about your life earlier, but it's that clear now. All right. Tell me, you were completely cooperative with the police on this when you were
I
arrested?
told them where everything was, and they stopped me. I told them where everything was. I did not tell them.
You didn't hesitate or?
Oh, they say, can you search the area? I said, you go that trunk. You open that trunk, in that trunk, they have 2 guns that's not loaded.
All right. Let me just refresh your memory what the police said, which is different from what you're saying. I told, I had Williams exit the vehicle and speak with Officer Allen. And I spoke with Thomas. And I began speaking with Williams. And I asked for consent to search his vehicle.
No.
Remember that? What did you do? What'd you say? What'd you say?
I said, yes, you can search my vehicle, but you can't search my trunk. That's what I said.
Right. You can search my vehicle, but you can't search my trunk where the guns are.
When they asked me that, I said,
Where the guns were, right?
told them,
You can search my car, just not my trunk.
told them what the guns was. I didn't want to search.
I had dispatch. That's not what happened. That's not what their report is. I had dispatch check Williams for both national and local warrants. Due to his comments, I asked if he had any illegal narcotics in the vehicle. He said no. Then I had the K9, the dog respond, conduct an open air sniff. Are you going to interrupt me? Yeah, I see what happens here is you're in an environment where you control. Oh, you got 7 convictions. You're free fall. And dispatch advised Williams had 1 city warrant along with multiple Jefferson County warrants. So I placed him under double lock hand restraints and advised him he was under arrest. I asked him for a 3rd time, do you have anything illegal in your vehicle? Then you finally said, after being arrested, you had 2 pistols in the trunk. And then, so they searched the trunk. Inside, 2 handguns. And there we are here today. And this is, now remember, this is in June of 23. And you, at this time, had 3 felony convictions already. So you can't be in possession of power, as you know. And so here we are.
Were those warrants, Judge, traffic tickets?
Yes.
So
So the last time
I don't know.
You were put on probation and revoked for the state jail felonies. You received a year on each of those, I believe.
That's correct, Judge.
Okay.
The only other fact, Judge, that I failed to mention that I'd like for your Honor to take into account is both of those guns were stolen firearms. That I'm not sure that that's as detailed as it needs to be in the PSI, but after they ran the information.
Well, we don't have, you're not saying you have any proof he stole the guns. So.
No, but they were initially looking at a theft of firearm charge. Yes, sir.
That's why you can't get around them, because you don't know what the history of them are. You don't control that, but certainly you can't get around them. You can't have possession of them. Here you are. You got 2 guns, 2 firearms. And you know that we're serious about. And because you already have an unlawful carrying of a weapon conviction. So we make a big deal about it. Anyway.
In the event that the court is considering probation for him, Judge, I would merely ask that if you're considering that it be the deferred option, so the full range of punishment is open if he should fail.
All right. Anything else anybody wants to ask?
I just would point out that since the 2008 and 7 convictions, and I believe that, though I wouldn't know how many convictions I had. He only went to state jail once, and I believe it looks like it was a plea bargain just to get rid of or combine all the cases.
But there are 3 wrongful acts.
But yeah, but there's 3 convictions, but he only went once.
Plus the 4 other wrongful acts of misdemeanor that he was convicted of.
Yeah, but those were back from 2014, was it, Judge? Were they?
That's the most recent.
What did the great author say? What's in the past is never really in the past.
2014?
Especially when you have criminal records.
The last one.
Especially with criminal records. It's never in the past.
Yeah, 13.
Yes, sir.
I would ask, Judge, that you would consider probation. You put him in the high caseload, supervision caseload, and he is employed. He does have family here. See what he does.
Right. And it states final rule response. You were asking for one.
I still think, Judge, my position is always going to be when a felon has a firearm that we should look at prison time. That's why I capped it at that. If you're considering the probation, I would prefer that it's deferred so that I've got a full range of punishment whenever he comes back. If not, then I would suggest that my original offer was 4 years. I still think that that's a fair amount of time, Judge.
The one thing you could do is give them weekends, 180.
Okay, under the recommendations as prepared by the probation office, that the court always pays a lot of attention to, because I respect their hard work and their great pride in 93% success rate on probation. Summary is the records in his case show that his criminal history is deemed extensive, and you have criminal activity going back 30, almost 30 years now, since 1997. And you received probation on other occasions. Those resulted in revocation. In this case, you took minimal responsibility for your actions, stating it was not mine, it was my friend's. He left them in my car. And the summary is the probation office just did not feel comfortable with your lack of what I can infer as you just weren't forthright with us. And right now, we have a proliferation of firearms running around this county. Just finished the trial yesterday and the jury wasn't lenient. They've had it with people that's using firearms. It's a privilege. It's a privilege that you have to be proven in your criminal record to be responsible in using them. You shouldn't even be near this. You knew it was in there, and your statements were to the police were an attempt to not to be forthright. You weren't about to let them look in your trunk because you knew there was trouble. Okay. If nothing further in this case, earlier you pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. So there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in your plea hearing earlier to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt. I'm following this agreement. It is whatever sentence shall not exceed a cap of 5 years imprisonment. You are hereby found guilty beyond a reasonable doubt, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. And you will be given credit for all time you have served in conjunction with this. You've been on probation before and you failed. And you came right back and got involved in some things you shouldn't have. And we are the 22nd largest county with the 16th highest crime rate, and most of it is gun use, misusage. This court is going to do its part to try to protect this community. You've got to do your part to act responsibly, sir. And you've got a family at home that relies on you. You got no business peddling around town in vehicles with firearms. You need to stay away from those, especially with your criminal history. It's an automatic felony when you're found in possession of it. It could be a federal crime too. Anyway, that's the order of it. Well, thank you.
So yeah, I got to push back on Judge there, and he's smart. He should know better. He just said that a gun was a privilege. That is 100% wrong. The right to keep and bear arms, shall not be infringed. Now, it has been established that you can lose your constitutional rights via your behavior, but I don't like the way he stated that. Owning a gun is not a privilege in this country. It never has been. It is a right. You can, you can cast that right aside by your behavior, but it is a right. I'm just saying. All right, let's do something new for the channel. At least I've been watching this judge backstage for a couple of weeks now. This is Ingham County, Michigan. This is Judge Rosemarie Acalina. Let's see what's going on there.
This is docket 22395 FC, People of the State of Michigan versus Ethan Deaton. Counsel, your appearances for the record.
Good morning, Your Honor. AP Barbucks on behalf of the People of the State of Michigan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. Have you had any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're
Yes,
not
ma'am.
on? Any sign you are?
Yes, ma'am.
What, is it anything that would interfere in your ability to understand the court?
I don't think so, no.
Okay, how long have you been
It's
off?
like, since I got here, I didn't take it today. I went to probation, so about 2 days, 3 days.
Okay, so how long have you been in, when were you arrested?
Wednesday.
So it's Friday, so Wednesday, did you take the medicine Wednesday?
No, I did not.
Okay. So 3 days, okay. And despite not taking it, you think you're able to understand things?
Yeah,
Any sign of fever, COVID, or other illness?
no,
All right, we're gonna get you an attorney. This is an arraignment if you want one. This is an arraignment on a violation that's alleged against you, on bond conditions. I had placed you on probation after you pled guilty to criminal sexual conduct, second degree, person under 13, defendant 17 years or older. It was an attempt. So instead of it being punishable by 10 years, it was punishable by 5 years. And there is a second count of that. So 2 5-year felonies. You were placed on probation and you were not supposed to have contact with any minors. And the allegation, count 1, reads as follows. On or about February 20th, 2026, defendant had contact with a minor age 17 or under, a violation of your probation. You have a right to remain silent. Anything you say or write can be used against you. You also have a right to an attorney, and you can also choose to represent yourself. There's a presumption of innocence until proven guilty by preponderance of the evidence, which means more likely than not, once you get into probation, it's not beyond a reasonable doubt, and you can have the people prove their case and cross-examine any witnesses and evidence they bring. You also can choose to provide a defense, but you do not have to. If you choose to testify, then people could cross-examine you. If you remain silent, your silence cannot be used against you in any way. If there's witnesses and evidence you wish to present, you may. The witnesses, however, would be subject to cross-examination by the people. Do you understand your rights?
yes, sir.
All right. So would you like me to appoint you an attorney?
Yes, sir.
All right. And sir, we'll make that happen and set this for a hearing. And at this point, we'll just plead not guilty. I know you keep looking back there. Who are you looking back at?
My mom and my brother.
Okay.
I'm sorry.
Okay, that's okay. So they're here. And I know your mom earlier on the record said that you didn't have an attorney. I said, we take care of that. So we're going to appoint you a public defender. Is that okay? Okay. And let me see. You previously had Scott Grable, but I don't, was he was retained?
Yeah, he retired.
Okay, so we can appoint you one at county expense. However, if you wish to retain an attorney, just let us know and that's okay.
Yes, ma'am.
All right. So did you say you had some time? Was that next Wednesday or I don't know. Okay.
April 8th.
April 8th. What time?
1.
All right, April 8th at 1 o'clock, we're going to set this for a contested probation violation. So, sir, do you still live on Old Ivy Lane?
Yes, ma'am.
And who do you live with?
My mom, my dad.
Okay, who else is in the house?
Just a cat.
Okay,
So,
and how old is your girlfriend?
22.
She's shaking her head, yes, okay. And does she have any children?
Yes.
Okay, well, sir, you can't be around her child. Okay, so that's a no way, no how, unless you get permission, and then she would have to be there 100% of the time. Like she couldn't even go to the bathroom without and leave you with the child, whatever that is. So, can you give me a bond form? Are you working?
Yes, I'm doing Instacart.
Okay.
Can I ask one thing?
Yes.
Okay.
Yeah.
Like if she takes a chaperoning class, how would that work?
What do you mean I don't know of any chaperoning class.
The probation officer that I had before Chance that I transferred over to Lincoln County, they said that whoever like family wise or something like that could take a chaperoning class.
Okay.
Which I could be around their kids and stuff, just as long as they're in person there.
Okay, you can't be around anybody, anytime, who's minor, unless I say so. So I don't know about the chaperoning class. I'm happy to learn about it. But it's not just you take the class and then you're free to do what you want.
I'm sorry.
We have, no, that's okay, you don't know about it. I just need you to understand that I'm your other mother now. Your mother's here, but I'm your other mother. Think about it like that. But my powers are different than your mother, okay? I can send you to jail. I can revoke and send you to prison, so I need you to follow 100%.
Yes, ma'am.
So if probation agent thinks that's a good idea, and I sign the orders and everybody's in approval, that's fine.
Yes, ma'am.
Okay. So check it out with probation and then have them get me some information and we'll talk about it, okay?
Yes, ma'am.
But meanwhile, don't take matters in your own hands because you end up in that jumpsuit and not working. So the meds you're taking, are they for ADHD?
Bipolar.
Okay. So are you still taking any ADHD meds or no?
No, ma'am.
All right, sir, I'm giving you a $50,000 PR bond. You'll follow all probation orders. You'll remain employed. If you don't have that job, you'll be part of a work seek program. Hopefully you get that back. And you will not have any contact with any minor under 18 years, so 17 and under, no, without permission of the court and supervision of the minor by the parent or guardian at all times. You'll continue to take all your meds and follow the prescribed recommendations of treating physicians. I think we've addressed, I looked at your probation orders, I think we've addressed everything else, including these. Some of them are repeated, but I wanted to make sure you understood.
Yes, ma'am.
Anything else I need to address? Any questions?
If I get on a bond, does that mean I continue my probation to my probation officer?
Yes.
Alright.
So you'll be released today, report to, do you know when your next meeting with probation is?
Every Wednesday.
You don't need to sign an order, you do whatever, or they need to, whatever it is, but
Alright.
it's, I mean, you've been on probation for a couple of years now. You ought to know the rules.
I just didn't know how that worked with the class thing.
That's why you have a probation agent, and then the probation agent contacts me. If you're having a problem with your probation agent, well, let me know, or let your attorney
I
know.
mean, kind of sometimes getting in contact with her is kind of hard, like text her, call her.
It should not be hard, so if that's a problem, then you need to let me know, okay? So, problem with probation agent, let me know, or let your attorney know, but, I will take care of that immediately. Mom, you're raising your hand, please, you need to come forward.
Can I just ask?
You cannot say anything, or I'm gonna put you in lockup. I've already had some conversations with you. I need you to come forward so I can talk to you. There's a protocol here. I need you to follow it, so please come forward and stand next to your son. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand up. Please state and spell your name for the record.
Bonnie Lee Stone, BONNIELEESQNE.
All right, see, everybody who speaks, we have to make a record of. This is
Okay.
for your son's, if he wants to appeal any of this, we can't just have people shouting out things or raising their hands. I have to follow the protocol. That's why I'm trying to tell you. I'm not trying to be mean to you, but without that, we have a transcript that is very sloppy, don't know who's talking, and the Court of Appeals is gonna hammer us both.
Okay.
Okay, so what is it you'd like me to know?
I just wanted to ask, okay, he didn't realize Beth Jantz and Jessica Fry.
Sir, wait a minute. I mean, ma'am, wait a minute. If you're gonna talk about the case, you need to talk about it with the prosecutor, with his attorney.
No, I just want to ask you about the class. That's what they got a hold of whoever for him to take the class to be around my grandchildren and a friend of his children.
Okay.
So that's why he just had his girlfriend go take the class. He should have asked the probation officer, yes, but she does have the paperwork.
I don't really give a crap, ma'am. Because you know what? The probation agent is telling him to take classes I know nothing about. And ultimately, the probation agent cannot say he can have contact unless I say so. So when all of that's put together, please tell your probation agent to get me the information. And I do allow contact all the time. I'm not trying to be a hard ass here, sir, but here's what's going to happen. See all this law enforcement? You're going to have quadruple that if they find you with a child. Okay, so it has to be documented under what conditions, they need to be approved by me, and we need to do everything right. And that's going to be your life pattern now till we get through all this. So I understand what you're saying, ma'am, and I know the probation agent believes whatever, and that's a great foundation, but it can't happen until I'm informed and I order it, because without that, the law enforcement's going to stop his vehicle and say, you're with a child. We're going, I'm arresting you now. Okay. Because the probation agent is not the judge.
I'm aware.
They are there to help, and that sounds like a great help, but I need an order that says that, and he'll need to carry it with him. Does that make sense to you?
I think all I'm trying to ask you is if it would be okay.
It's okay once I'm informed and an order is signed. Right now, I know nothing except what you all have asserted. I need to sign. See, like right now, you're gonna get an order here that we're all gonna follow. So, like me swearing you today, ma'am, everything in law, it's a lot of paperwork, a lot of rules, and if they're not followed, the one that's in jeopardy is not me or you, it's him.
I know.
Law enforcement needs to know he's followed all the orders, or he gets rearrested and rearrested. Waste of everybody's time and taxpayer money. So we're gonna do it by the book, and then he'll get what he wants. As long as there's proper supervision, and I'm glad there's classes. I was not aware of that, so I'm glad for the education today. But we've got to follow the rest of the dots, and then I will sign it, okay?
Okay.
Pretty much covers everybody, my side, your guys' side, everybody's side. Pretty much.
Yep, we gotta cover everything, okay, sir? So you get whatever information from that class, have your probation agent contact me, get a copy of whoever are the supervisors that they've taken the class, and we'll do an order and we'll get it taken care of, okay?
Yes, ma'am.
Any questions?
No, ma'am.
Does that answer your questions, ma'am?
Yes, ma'am, thank you.
Okay, I worry about people telling me things because it's not in an order, which means it doesn't exist in the legal world. And that's a problem.
I understand. He went about it the wrong way this
Yes,
time. He
so-
didn't understand.
I know, I'm trying to explain it the right way, okay? Do you have any questions that I can answer?
No, ma'am.
Okay, we're gonna get you all a copy of this. Would you make a copy for mom, or grandma too, or mom, whatever? All right. Thank you. We'll see you. You'll be released. You can pick them up in Mason, and then you follow all the rules, and
Yes, ma'am. Do
we'll get you
everything.
copies in a moment, okay?
Yes, ma'am.
Thank you.
Okay, friends, we'll continue to ride with this court for a little while since you guys seem to be enjoying it, judging from the feedback I'm seeing in the chat. But yeah, this is a judge who's a little bit of a hidden gem, but this is why you stick with us here at TCF. We try new things. We try out new judges. We look around. Yeah, we've got our favorites that we go to because, of course, we do, because there are people that we love. But it's the moving around that finds us new things. And she's a hidden gem. She doesn't have a lot of subscribers. She doesn't get a lot of views, but she's great. Like I said, I've been watching her for a couple of weeks behind the scenes, just kind of getting a feel. So we'll stick here. Just an FYI, though, about this judge. She is not somebody who would be in our daily rotation because she does not stream daily. There can be some significant gaps in her calendar, but when she's available, we'll certainly give it a look. All right, back to court.
Here we go. Counsel, is this going to be a plea?
Yes, Your Honor.
When you're ready. File. This files. All right, this is docket 251695 FH, 251699 FH, 254883 FH, 251697 FH. People of the state of Michigan versus Lucas Lorenzo Tapia. Counsel, your appearance for the record.
Good morning, Your Honor. AP Burbucks on behalf of the people of the state of Michigan. And just for clarification, there is also 25-1701 FH.
Good morning, Your Honor. Dustin Cruz for Lucas Tapia, who's here to my right.
Thank you. All right, I do have that file, but I do not have, it was just didn't make it on the docket, so I've added it. All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Sir, when you're not in lockup, do you live on Pinehurst? Do you have an address?
No.
He's currently serving a 45-month sentence with the Department of Corrections, Your Honor.
I see. Okay, thank you very much. All right. And have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
And have you had an opportunity to speak with your attorney?
Yeah.
All right. And I understand there's going to be a plea today, is that correct?
Yeah.
And you understand you're waiving your right to a bench trial or jury trial by pleading?
Yes.
All right. And are you a U.S. citizen?
Yes.
At the time of the counts that you're pleading to, were you on probation, parole, or bond conditions on other files?
No.
It might have been he was on bond on these other files.
You're on probation.
Yeah.
Okay, so have those been dealt with, or will he end up facing? The reason I ask, sir, is you could possibly face other penalties because you would have violated bond or probation or parole. So you need to be aware of all of the possible penalties. So I don't know. Have those cases been taken care of?
Your Honor, I think at the time he was on probation, Oakland County, that case has been closed out.
Okay.
So
we don't anticipate any other punishment. Let me just say for the record, if it was on mine, won't address those because we're addressing this as a global resolution, I understand.
That's right.
Okay. And there was nothing else pending that we are aware of?
Yeah, there have been a number of cases. I'll get into this more in my allocution, but I think the only thing he was under supervision for at the time was on probation of Oakland County. That's been dealt with it. Probably on bond of Genesee County, I think, and those cases have been dealt with as well.
Okay, appreciate that. Thank you. All right. On behalf of the people, what is the opinion?
Yes, Your Honor. As you would say, there will be a global resolution in this matter. The defendant in this case will be pleading to two of these files. In 25-4883-FH, the defendant will be pleading to an added count 2, retail fraud in the second degree. As a result of that plea, counts 1, retail fraud in the first degree, will be dismissed. In 25-1699-FH, the defendant will also be pleading to an added count 2 of retail fraud in the second degree. After successful plea and sentencing, count 1, retail fraud in the first degree, and the habitual offender second status will be dismissed. Additionally, 25-1701-FH, 25-1697-FH, and 25-1695-FH will be dismissed in their entirety at successful plea and sentencing on the other two matters.
What about, I'm sorry, 25170, is that also being dismissed?
Correct, Your Honor. There is also an agreement to immediate sentencing on this case, Your Honor, and that the defendant agrees to a restitution amount to $688 to Kohl's, $1,999.96 to Target, and $4,111.98 to Home Depot. That is the amount of the restitution on all 5 of these files.
Full, fair, accurate, and complete?
Yes, Your Honor.
Sir, full, fair, accurate, and complete?
Yes.
And counsel, you're reading count 1 on 25-4883-FH, count 1 and habitual second on 25-1699-FH, as well as the entire files of 25-1701 FH, 251697 FH, and 251695 FH, and 25170 FH.
Yes, Your Honor.
As to the reading of the felony information on the two files.
Yes, Your Honor. The people of the state of Michigan versus Lucas Lorenzo Capio. State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in added count 2, retail fraud second degree, on or about December 7th, 2024, at 1710 Newman Road, Okemos, Michigan, 48864, Hingham County, state of Michigan. The defendant in a store or in its immediate vicinity did, while Kohl's was open to the public, alter, transfer, remove, and replace, conceal, or otherwise misrepresent the price at which the property was offered for sale with the intent not to pay for the property or to pay less than the price at which the property was offered for sale, which the resulting difference in price being $200 or more, but less than $1,000, contrary to statute. This is a misdemeanor that is punishable up to 1 year and or $2,000, or 3 times the value of the difference in price, property stolen, or money or property obtained or attempted to be obtained, whichever is greater per case law. For the court to impose an increased fine such as 3 times the value, or a fine that is calculated based on the number of incidents or length of time of the violation, the value / incident / duration must be determined either by the trier of fact or admitted by the defendant. For a second or subsequent offense under MCL 750.356D, the court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution per statute, and against a piece of AD of the state of Michigan. That is 25-4883-FH. In 25-1699-FH, people of the state of Michigan versus Lucas Lorenzo Tapia, state of Michigan, County of Hingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appeared before the court and informs the court that on the date and at the location described below, the defendant in count 2, retail fraud second degree, on or about January 11, 2024, at 4890 Marsh Road, Meridian Township, Hingham County, state of Michigan, the defendant did, in a store or in its immediate vicinity, did, while target was open to the public, alter, transfer, remove, and replace, conceal, or otherwise misrepresent the price at which property was offered for sale with the intent not to pay for the property or to pay less than the price at which the property was offered for sale, with the resulting difference in price being $200 or more, but less than $1,000, contrary to statute. This is a misdemeanor punishment up to 1 year and or $2,000, or 3 times the value of the difference in price, property stolen, or money or property obtained or attempted to be obtained, whichever is greater per case law. For the court to impose the increased fine, such as 3 times the value, or a fine that is calculated based on the number of incidents or length of time of the violation, the value / incident / duration must either be determined by the trier of fact or admitted by the defendant. For a second or subsequent offense under MCL 750.356D, the court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes.
So you understand in both files there, you'll be pleading to the misdemeanor, retail fraud second, and that's a 1 year misdemeanor and or $2,000 along with restitution, and you are owed, or you must pay restitution on all files. And it looks like you've agreed to the amounts, and that's to Kohl's, Target, and Home Depot. The prosecutor read the amounts. You're in agreement?
Yes.
All right. And this is a victim rights, technically, usually the stores don't show up, but you complied with the victim rights.
Yes, Your Honor.
All right, thank you. And sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yes.
And if you had any questions about your rights, you were able to ask those of your attorney?
Yes.
Do you have any questions about your rights of this court?
No.
Sir, as to count 2 retail fraud, second degree in docket 254883, how do you plead?
Guilty.
And as to retail fraud, second degree in docket 251699 FH, how do you plead?
Guilty.
You understand that if someone forced, threatened, coerced you, promised you something in order for you to plead, other than the plea agreement, you need to tell me that now, because if you come back later and say, Judge, I shouldn't have pled, I don't have to allow you to withdraw your plea. Do you understand that?
Yes.
You pled of your own free will,
Yes.
and you did that to both files. You pled of your own free will.
Yes.
After you discussed everything with your attorney,
Yes.
and you've been satisfied with the representation of your attorney?
Yes.
And you understand, as I said earlier, you're giving up your right to a bench or jury trial, but you're also giving up your right to a presumption of innocence, to the ability to cross-examine witnesses and evidence, to choose to provide a defense, to have an automatic right of appeal. Now you would have to ask permission of the Court of Appeals to appeal, and they're only going to take your case if they think your issues are important. You understand all of that?
Yes.
Has anyone told you, other than the restitution, which you've all agreed to, what I will do at sentencing?
Yes.
They have?
Or my word.
Well, it's not a trick question, okay? Did anyone, other than the plea agreement, did they tell you what I will do at sentencing?
Do it sentencing?
Yeah, how will did they tell you how I will sentence you, what I'll do at sentencing? What terms of the sentence will be?
No.
That's the right answer. Because I'm not fully informed, I'll learn some more now, and your attorney will talk to me and so will the prosecutor, and then I'll make up my mind what happens. Do you understand?
Okay. Or yes.
Okay. Turning to the 254883 FH file, did this offense occur on or about December 27, 2024?
Yes.
In the township of Meridian, county of Ingham, state of Michigan,
Yes.
at a specific location known as 1710 Newman Road in Okemos, the Kohl's store?
Yes.
You entered it when it was open for business,
Yeah.
and you took items that did not belong to you,
Yes.
and you had no intention of paying for them.
Yeah.
And were those items offered at a price of, and I don't remember for the misdemeanor what it is it $200?
$200 to $1,000.
$200,000 to or more?
Yes.
What were the items, you remember?
Sure, can I show them the police
Sure.
report?
Yeah. Clothes, bunch of clothes.
Shoes.
And shoes.
Okay. And were they returned in a saleable condition, or did you get away with it?
I didn't return them.
You didn't return them. Okay. On behalf of the people.
People are satisfied in regards to that file, Your Honor.
I'm satisfied, Your Honor.
Turning now to docket 251699 FH. Did this offense occur in the township of Meridian, county of Ingham, state of Michigan?
Yes.
At a specific location known as 4890 Marsh Road in the township of Meridian, and it's the target,
Yes.
and that's the one on Marsh Road. All right, yes?
Mm-hmm.
Is that a yes?
Yes.
And that was on or about January 11, 2024?
Yes.
Again, you entered it with the intention to take things that didn't belong to you,
Yes.
and you had no intention of paying for them, is that correct?
Yes.
And were they offered for a sale price of $200 or more or less than $1,000?
Yes.
And what did you take?
It was vacuums.
Vacuums?
Yeah.
And did you leave the store with those?
I did.
So they were not returned? Okay. And so you understand that that's the reason for the restitution?
Yes.
So yes? Okay. And you would also agree, although you're not pleading to this, that you took items from Home Depot that were not returned as well?
Yes.
So I have the Kohl's amount of $688. You agree to that?
Yes.
I have the Target amount of $1,999.96. You agree to that?
Yes.
And you agree to $4,111.98 at Home Depot?
Yes.
All right. On behalf of the people, any additional questions?
Well, people are satisfied now. Counsel?
I'm satisfied, Your Honor.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the courtroom?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made that under influence, threats, coercion, and promises of leniency on each file. I also find that on each file there are sufficient grounds to accept defendant's plea. Therefore, count one will enter on docket 251699 FH. And
Sorry, Your Honor, was that count?
I'm sorry, yeah, I was just looking at that, sorry. Count two will enter on docket 251699 FH. Count one, along with the habitual second offender notice, is hereby dismissed. And on docket 254883 FH, count two will enter, count one is hereby dismissed. In their entirety, docket 251701 FH, 251697 FH, 251695 FH, and 25170 FH are dismissed in their entireties. However, the restitution as indicated will remain under these open files, and if there are any outstanding warrants on any of these files, those are hereby recalled and dismissed. I don't know if any contraband was seized at the time, but if there was any, that is also forfeited. We have a sentencing date?
Your Honor, we're agreeing to immediate sentencing.
Oh, I forgot. All right, sorry. All right. You agree with that, sir?
Yes.
Counsel?
Thank you, Your Honor. Lucas is probably growing a little tired of me kind of telling his story the same way over and over, but I've known Lucas for a little over a year now. We first met shortly after he was caught on this Coles offense while he was residing at the Eaton County Jail. I've represented Lucas in Lenawee County, Jackson County, Genesee County, Eaton County, Ingham County, Oakland County. We also have a Macomb County case outstanding. And there's a common thread that unites all of these cases, and I'm sure the court could venture a guess as to what that is, and that's addiction. More than that, and I won't name any names, but Lucas, I'm not trying to remove him from his responsibility in all of this, but he was more or less a pawn in a greater retail fraud scheme, one that's being prosecuted by the Attorney General over in Eaton County. The kingpin of that is currently on the lam, but his sort of mode of operating was to recruit people like Lucas who are addicted to drugs, have them go do the actual stealing, and then he would not even pay them in cash. He would take them straight to a flop house where they could get high. And, Lucas is responsible for his part in all this. But that's what this is all about, is addiction. And, when I first got to know Lucas a little over a year ago, he was maybe a month removed from the last time he'd gotten high. And now he's 14 plus months clean. It was December of 2025. Is that what you? Yeah. Okay. So it's just a world of difference. I mean, he's a different person. The person who stands before this court today is thoughtful, kind, caring, actually has a history of being an incredible entrepreneur. He's built a couple businesses successfully, but it's, you know, when addiction gets in the way, that's when he's here. He's currently serving, as I indicated earlier, he's about 14 or so months into a 45-month sentence out of Eaton County. It was actually almost identical to the 1699 FH case here. He went into the Target on the west side, stole some vacuums. A Target employee confronted him, and in trying to get away from her, made physical contact, kind of pushed her into the door jamb, I think it was, and she got a small laceration. So that retail fraud turned into an unarmed robbery. That's why he's serving a 45-month sentence in Eaton County. We're asking that this court just consolidate these matters into that sentence. I'm asking for no further time. Obviously, there's some financial implications here, the restitution that's been agreed to, the fines and costs that the court can't waive, but we're asking.
do you have the docket number of the file he's serving under? And then I'll allow you to speak. We did it a little bit reverse, but I wanted to hear it there.
And I do have those case numbers right here, Your Honor.
You do have what he's serving under? Yeah.
Yes, he is serving under, it is 25-20021 FH, 25-20024 FH, 25-20023 FH, 25-20022 FH, and 25-20020 FH.
So yes, there were a number of files in Eaton County. It was the Target incident that was the most serious, which is out there.
Okay, thank you. On behalf of the people, I kind of figured it, so usually I go in the order of you and then defense, but I wondered about the how he got all these things out. I figured there were some co-defendants. So my question for you now is, what would you like me to know? And then where are we with any co-defendants? Because technically what I'm going to order is the restitution, but joint and several. I don't know that they've been charged or where they are, but it would be joint and several once they are.
Sorry, guys, I want to pause for just a minute because this is going to keep going. But I wanted to let you know I have eyes on Judge Simpson's court because they're gearing up for an evidentiary hearing for the Sharon Moore case. Sharon Moore being the former University of Michigan football coach who was fired for allegedly having an affair with a staffer, and then allegedly later showed up that day at the staffer's home with a knife, threatening to hurt himself and all sorts of stuff. So I want to go to that when it goes live. And I just want to make you aware, because if this keeps going, I might leave it to go there, because this is the kind of hearing that Judge Simpson is probably going to kill just as soon as it's done. So I want to capture it. Just an FYI, but let's get back to this one.
So I will say, Your Honor, the only case that I see a co-defendant on, I have to apologize, I'm taking this over for Prosecutor Matusko last minute. I'm seeing a Joshua Day on 25-1695. I'm not seeing any co-defendants on other cases. In regards to that one, I believe that's the one of the Home Depot matters. It looks as if Mr. Day has already pled guilty on that matter.
Was he one of mine?
Yes, he was, Your Honor.
All right, well, do you have that file number?
I do. It is 25-355 FH.
All right, well, I don't know if I ordered restitution on that or not, but
I can look, Your Honor.
All right, we need to amend it to be joint and several between them.
I do see restitution was ordered, Your Honor, in that file.
Was that the same amount as what we have here?
Let me look, Your Honor.
I mean, in fairness to both, if he did something different, that's on him, but if this was...
And I do see a global in that case, so I believe that Mr. Day also had a multitude of cases that had restitution on them, but let me check let me look at the PSI one moment, Your Honor.
And I think Lucas's Home Depot restitution spans at least 2, maybe 3 cases that were dismissed as part of this, so.
Yes, and the 1965 is the Home Depot case.
Okay. And so that would have been, let me just look at that.
So I'm seeing in this case a total of $5,408 restitution to Home Depot, Lowe's, Meyer, Kroger, Marianne Mizar, and Constance Cleary. The amount that I'm seeing from Home Depot here is $3,141, which to me seems to indicate that Mr. Day had a similar situation where he paid a multitude of cases in regards to the Home Depot.
So let me just say this, the 3,149, I don't know if that's separate or if that's inclusive of this.
That is inclusive in the ones, the restitution amount for Home Depot, that's inclusive to the 3 cases that were dismissed, Your Honor.
Okay, but not, so if Day is a co-defendant, here's what I'm gonna do. I'm gonna order restitution, but I'm gonna have it joint and several, provided that you could untangle this and see who's responsible for what. I don't know.
I can do that, Your Honor. I do have the numbers. So if you give me one moment. The one where Mr. Day pled, that is in the 1965 file, and the 1965 file was $1,197 in restitution. So that one would be joint and several in regards to Mr. Day. I do not have any co-defendants on the other files, Your Honor.
Okay, well, let's figure it out. I think in fairness, we need to make some kind of chart for both of them, so it's joint and several. I think you're all astute enough to figure it out, and then I can sign whatever order, or you can do a special order, or I don't know. Does that work for you, counsel? I don't
Yes, Your
think
Honor.
it's fair that he pay everything.
Yes, Your Honor. And I suppose if there's a resolution to that AG case at some point, that I might, well, I'll file a motion if necessary.
Yeah, just let me know so we can get to that. All right. And so on behalf of the people, what are you asking for in regard to sentencing, or is there anything else you want me to know?
Your Honor, I at this point in time, I believe that everything that we would wish for you to know exists. The defendant is an MDOC. He's on these multiple Eaton County cases. Obviously, he had 5 retail fraud cases. 3 of those are being dismissed. So I leave in the court discretion.
All right, and I need to know how many days jail credit does he have on these? Do we know?
I'm seeing a date of sentence in the Eaton County case on September 18th of 2025. But I am not sure exactly when he got picked up on those Eaton County cases.
Would that also count for us? It just depends on. So here's what I'm going to say. I'm going to sentence him. We have 2 issues to figure out: jail credit on both files and restitution. Otherwise, I'm not doing my job, and neither are you, and we can't have that, because the victims are entitled to that, and defendant's entitled to the credit. So I'm sure that when he's sent back over to the jail or whatever, we can figure it out, because I've got a clerk here who's gonna have blank boxes because we don't know. Is that something we can do? He's gotta get his credit. Sure, do you know how? Well, you probably wouldn't know.
Yeah, truthfully, Your Honor, I don't know if he has any. I mean, he has been incarcerated this whole time, but
I mean, in the long run, it's not gonna matter, but if we're audited, it matters, because here's what I'm gonna do. Sir, what would you like me to know? Anything?
Oh,
Sentencing, what was going on with you, how you're doing, anything you want me to know?
yeah, I'm doing much better now. I joined the substance abuse class that I'm taking, and been doing that the last couple of weeks.
So what was going on with you where you decided you're good in business, you've done some fabulous things your attorney tells me, and then you decide to hook up with these people and use drugs? What prompted that?
I had a wife and 2 kids, and we didn't work out, and I lost it.
Okay, and I understand.
And I going in Arkansas, and then I left and came here.
Okay, so going through a divorce is like a death, it's a grieving process. But there's nothing on the calendar that says something bad happens and I have a license to use drugs.
No.
And if you look around the world, there's a zillion other women
Right.
who would be happy to date a successful businessman.
Right.
And the best way to get over something and to say, look what you lost out on is to do great. Not so she can say, oh yeah, I left him and look what he's doing now.
Right.
Rise above it, sir, and be the example for your kids. Because just because you divorced their mother for whatever reason, it doesn't matter. You've got kids, and you have a constitutionally protected right to raise them, unless you're an unfit parent, and if you use illegal substances and you're locked away for 4 years, or actually our state says 2 years, your rights can be terminated. So do the right things, show your children that you can make a mistake, but those are all teachable moments, and you learn your lesson and you rise above and you stay above. Because those kids are depending on you. How old are they?
9 and 3.
So you're gonna miss some critical years, so you got a lot to make up for.
Yeah.
Anything else you want me to know? All right, is that a no?
No.
On each file, I'm sentencing you to 1 year jail, which will run concurrent with the prison sentence you're now serving. You will receive your jail credit days once we figure them out, and you will pay restitution in the amounts that are agreed to. And it appears, I know we have them, but for the record, it is $688 to Kohl's, $1,999.96 to Target, $4,111.98 to Home Depot, and those will be joint and several with any co-defendant once we figure that out as well. It looks like you have at least, on the one file, you have, I do have that name of Joshua Scott Day. So we'll figure out where the offsets are. So that means joint and several means, and that was to the Home Depot, right?
Correct.
So the Home Depot is $4,111.98. It might be that you pay $3,000, he pays the rest, or you pay $1 and he pays the rest. It doesn't say 50% each. That's not how restitution works. Okay, on each file you will owe a $75 crime victims and a $50 state cost, and that's a total of $125 on each file, or $250 total. However, restitution is due immediately, but the state cost of crime victims will be due 12 months after you're released from prison. I'll hold that until then. You have 42 days to appeal and to request appellate counsel. You'll need 2 appellate rights. And while you're incarcerated, I want you to just continue with your mental health treatment, trade school. Do you have your GED?
Diploma.
Diploma? Good. Okay. And anything else you want to participate in? They're not letting you, or?
No, I'm going to be doing trade school too the last 18 months. You can do that.
Great. So I'm ordering it, so hopefully that'll move you up on the list. All right. Anything else?
No, thank you, Your Honor.
All right. Thank you. Good luck
Thanks.
to you, sir.
Okay, I think she will henceforth and forevermore be known as Judge Other Mom, because I just kind of liked that when she said that she was the guy's other mom. So again, I have eyes on Judge Simpson's court. They haven't started yet, but I know what that hearing is going to be, and I want to cover it if if they actually get it going here soon. It is Friday, so during the 4th hour, we generally go to Dungeon Court, and that is an option for us today, but this Simpson thing will supersede Dungeon Court, depending on how the timing works. Just bear that in mind. But for now, let's stay in Michigan. Where'd my mouse go? Doggone it. There it is. Okay. Let's stay in Michigan, but let's go back to Judge Middleton.
Oh, okay.
Do you have that file?
No, I checked with district and they indicated you should have everything.
Well, that's the worst case scenario. They gave it to me. I have a felony case. Good morning, Mr. Montgomery. We met yesterday afternoon. Mr. George was here on another matter, and we did a very brief bench warrant arraignment in this case, which is 25278 ST. You're charged with driving suspended second offense. That is a misdemeanor. It's punishable by up to 93 days, up to a year in jail and a fine of up to $1,000. It carries 2 points and it requires that your driver's license be suspended. We did a brief bench warrant arraignment yesterday, as I said, and scheduled the matter for this morning. Mr. George, what's the status here?
The prosecutors offered that if my client would enter a plea to no valid operator's license, the driving suspended second offense would be dismissed.
That's a pretty good offer. No valid operator's license, Mr. Montgomery, is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points on your driving record and will go on your driving record. Your license is already suspended, but this will go on there. Do you understand?
Yes.
You understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury.
Yes.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you, and they have appointed Mr. George. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Were you driving a car? Let's look at this ticket again. On February 14th of 2025, about a year ago.
Yep.
And was your license suspended at that time?
Yes.
have 2 days of jail credit. You might have some at the front end. He didn't show up last March for Judge Pattison. He issued a bench warrant. And then you got picked up on that bench warrant a couple days ago. You got arrested in June and posted a bond, and then you bugged out again. So you had 1 day in June, 2 days now. Or 7 days jail, credit 3, leaving 4 days to serve, which is going to be concurrent with your new methamphetamine charge, 26360FY. 0 fine. I'm going to waive your attorney fee also. The minimum fee of $125 or 2 additional days, which should be swallowed up by the other time you'll be doing. I believe you owe me money. I had it on yesterday's cheat sheet. You owe money to the court, but I don't have it in front of me for today. We'll look into that in the other case. The new case is 26360FY. And as long as you're here, the magistrate asked me to just take care of this arraignment. That's not right. 25278 SD. Because I didn't have a bunch of other things to do this morning. All right, Mr. Montgomery, let's take a look at your new case. You got arrested on a charge of possession of methamphetamine. That is in file 26360FY. Complaint alleges that that happened in Montville Township on March 4th. Is this the place where you were in, they did the search warrant? All right, they charge you with possession of methamphetamine as a second or subsequent offense as a drug double, making it punishable by up to 20 years imprisonment. And you've been in custody since that time. I need to appoint a lawyer for you. They didn't give me the dates. I wish they would do that. I'm gonna show a plea of not guilty. I don't even have the authority to take a plea at a felony at this level. To show a plea of not guilty, I will appoint an attorney. Set a pre-exam conference. I think the dates are March 17th for the pre-exam and March 20th. The pre-exam would be at 8:30, and if a prelim is needed, it will be March 24th at 1 o'clock. In the underlying case we just did, you failed to appear twice. You failed to appear for your first arraignment. They issued a bench warrant. You actually failed to appear 3 times. Then you did appear and you got arrested in June, and then you failed to appear again, and then you got arrested yesterday or the day before. So in this case, you have appeared, but in previously case you failed to appear. You have an unpaid driving suspended case in 202483 ST. You have an unpaid domestic violence in file 23808 SM. And an unpaid disobeying a stop sign ticket. Failed to appear on the fast, failed to pay fine and costs. And it's a drug double. Set bond at $10,000 cash or surety. They gave me a whole bunch of stuff. Including the bond form. You shall appear personally for any previous or subsequent examination. You shall abide by any judgment entered by this court. You shall not leave the state of Michigan and do not commit any crime if you are released. Provide email and telephone number on release. Do not use any drugs or alcohol if you are released. No assaultive or threatening behavior. No firearms. You shall seek employment. All right, you're going to be taken back to the jail. The magistrate and the clerk will prepare the bond. If you're able to post it, you need to call your lawyer, make an appointment to discuss this case with them. You got 4 more days of jail to do on the driving suspended case. I don't think you're going to post the bond. I did not appoint Mr. George as your lawyer. He may end up in the rotation, but I'm not sure who's on duty that particular date. but this takes care of your traffic case and gets your felony methamphetamine case started. You told me you were in bed when the cops came and executed the search warrant. I don't know anything at all about the facts in this case. Your lawyer can explore that further. I suspect there's more to this. There usually is. But you can go back to the jail and get lunch. You're good to go. Thank you, Mr. George.
Alrighty, let's go down to Texas, see what's going on now with Judge Stevens.
What are we doing today? What are we doing? Anybody?
I'll defer to the statement.
It says MTRP status.
Yes,
And
Judge.
First amended to be filed.
Yes, Judge. The First Amendment was filed.
It was filed on March 2nd. So that
Correct.
was a few days ago.
Correct.
Does anybody, y'all have copies of that? No? Mr. Brooks, it looks like they've added, you failed to work faithfully at suitable employment and provide verification of such. You provided a urine sample on December 10th, 2025 that showed cocaine in your system. And you failed to attend Batter's Intervention Prevention Program BIP. Those are 3 added to the previous 5 allegations. All right, when are we going to hear this? 1 week? Y'all ready?
Judge, after speaking to probation, and I, and as well as defense, have come to a possible resolution of this matter. The biggest issue is if the defendant can test negative, and the state would request for him to be tested if possible today.
It was dated January 6th.
That was January, but
But he has such. He informs me that he will be negative for all substances this morning. He is on the care spinal top, you know, and makes
He
you.
tested positive in December. Come on, for cocaine of all things. He's been on probation since 21 for 10 years. And what the heck are you getting? What are we doing getting a positive hit for cocaine?
He self-medicates, Your Honor. Again, he's a mental health patient.
He's making the cocaine?
I'm trying to explain to the court what's.
No, where does he get the cocaine that's in his system?
We haven't get you, Your Honor.
Yes, it always is.
I've instructed him not to answer that. It's technically broadcast and he answers it.
Okay.
It may impede his safety.
Okay, you can tell him that.
If we would go off of
but
you, I'd be telling.
You don't direct this court about anything, sir. Don't
Don't
interrupt.
It would endanger his safety.
Sir,
If he answered.
sir, don't interrupt when I speak, please. She can't put that down when we interrupt. Thank you. Just don't interrupt me, please. Thank you.
I'll advise.
Okay, you advise him what you need to do.
We'll go off of you
Dictate-
too. We'll answer that question.
All right,
Okay.
y'all sit over there, please. We'll get back to you in a minute.
I have to be in part of the game.
I know.
Judge Thomas.
In the court.
Yeah.
Give me one. What are we gonna do today? What do we plan to do?
Judge, probation has agreed to continue him on probation if he can test negative. He's just.
I know, but yeah, but how does he purge the positive?
Right.
I mean, you can't undo that.
Understood.
Yeah, and you open the door for one, that's it. It's fair for everybody. Everybody tests positive, then they get free ones.
He isn't everybody. He has mental health.
I'm sorry. It's what's good for him is good for everybody in similar circumstances. That's my understanding of the rule since birth. It's what's fair. That's my job. Is to ensure it's fair, and yours is not to interrupt, please. Let me complete my thought. No, I'm not going to do that. We're going to set this though for a hearing in 2 weeks.
So he doesn't need to be tested soon?
No, that doesn't undo what happened before. If the test is a valid test, it's 2 weeks. Get a reset in 2 weeks.
Thank you, Judge.
But he been tested regularly?
Not regularly.
That needs to be done until we can get this hearing. Okay. I have Kinder Antoine. Yes, ma'am.
Judge, this is one that Mr. Boyd had before he left. I've been speaking with Ms. Porter about it, however, she was in trial this week. I think that we have things to talk about, so if we could just have a short reset on it.
Well, where is Mr. Anderson?
He's in custody.
Okay, he's in custody. How much time?
2 or 3 weeks.
Just 2 weeks?
That's fine, Judge.
Good, thank you. Reset those two.
Yeah.
Mhm. Gary Faulk,
He's in custody, Judge.
what do we do today?
He's gonna voluntarily plead true to his
Gary Faulk?
violations. And then we can go to you for a decision.
On this, let me ask on this thing that was given to him, Frank? Yes, sir. Who's, does the defense have that? Yes. Okay. Can you make a copy of that?
Oh, it's a copy. That's your copy.
Okay, thanks.
I gave him a copy.
That's for Willie's. That goes in the Willie's file. That's a copy for us, so we're okay. I just need to put it
You have the
aside.
file still, I think. You should have one file, you still have.
I got. Nice.
You want these copies too? That I gave you?
Everything, I'm gonna put it together, so. Yeah. Thank you. Gary Falk? That's you, sir? 23 CR 1750 is called. And there is a motion to revoke probation that was filed October 2nd of last year. You were here with Ms. McNally, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary? Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion states that on May 16th of 2024 in this court, you were sentenced to 18 months in the state jail. That was suspended for 5 years for evading arrest or detention, a state jail felony. But let's see, there must be prior convictions. Okay. A state jail felony, it's punished as a third-degree felony, correct?
No, sir.
No.
This is state jail. This is
18 months.
previous convictions makes it a felony. So he was running on
18
foot. It
months.
wasn't with the car. So
No, okay, because it's kind of true on the priors. There was.
because he was sentenced to 18 months, so they sentenced it as state jail.
3, 4 priors. So we didn't go on those third degrees.
No,
It's
sir.
just,
enhance it to make it a state jail felony. Should
could have been though.
It could have been.
Could have been.
That's correct, but
Yes,
it's not.
Could have been. Up to 20 years in prison as a potential. There's a lot of leniency given here. All right, so is all of that true so far? You were sentenced to 18 months in state jail and that was suspended for 5 years on May 16th, 24. Correct? All right. Allegation 1 states you failed to report to the probation office for May 5th, June 9th, July 10th, July 17th, July 30th, all 2025. Is all of that true?
Yes, sir.
And was he an absconder?
Yes, sir.
How long?
He was gone until he turned himself in.
Which was when?
December.
Okay, so from May to December, you never reported to the probation office, right?
May of 2025.
May 5th of 2025 to
December.
through December.
He did come in June 23rd and met with me, and then he was gone after that. He came in after I called him, and he did come in that one day, and after that, he was gone. So there was a June 23rd.
You gotta report or you're not on probation.
I couldn't make it to the appointment. I came in and told my PO she wanted to change my location, but I was in Beaumont and had to come to Port Orford.
Okay,
Yes, sir. And I let my PO know that I didn't have no reliable transportation.
we gotta figure it out.
I was in the process of moving, so I turned myself in.
When?
December.
6 months later.
So,
What happened in those 6 months?
I was in Beaumont.
Half a year.
I was in Beaumont and
You were on your own probation.
I was homeless.
You gotta figure it out, sir. If you're either on probation or not, but we accommodate people when they know. The probation office is very accommodating. We have a great success record. You're 1 out of 14 who fail. You're 1 out of 14. 13 out of 14 are successful. That's a great record. Allegation 3 states you provided a urine sample on April 14th of last year, which showed the presence of tetrahydrocannabinol, marijuana, and cocaine. Is that true?
Yes, sir.
Can you explain that?
I was I take medication.
Cocaine? Who's giving you the cocaine? Which doctor is that?
And health medication.
Well, you know that's wrong. You know it's illegal. And
Sure.
all right, are you pleading through then allegations 1 and 3 voluntarily and because those allegations are true?
Yes, sir.
Do you understand that a plea of true, voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 18 months
Yes, sir.
in the state jail. Knowing that, do you insist on pleading true to that?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Do you have a calculation of this? What time you last credit? How much time have you served in this case? Do you know?
Since December 28th.
No, before that. When you were arrested and waiting,
Yes, sir.
being put on probation, were you in jail a while?
Yeah, like a month.
Okay. Okay. Okay, thank you. I'm looking at the pre-sentence report where.
That's why I gave it to you.
Yeah.
Oh, 3 full pages,
Don't look at me like that, Judge.
huh?
Don't look at me like that.
Criminal history dates back to 1988, so that's 38 years.
28, 1998.
Today's 26, 88. 12 plus 26 is,
I thought you said 98,
I'm gonna give you,
because you were aging.
would you like an
me.
abacus to
No, but if it was 98, then you were aging me 10
88.
years, and that's not.
88
Okay.
to
88.
26, which is 38. And that's you have to look at the whole book here, not just a few chapters. You have as a juvenile, there were 30 some odd dispositions. Most of these were runaways and other things. Your home life must not have been a solid one, huh? Okay. And then we start with adulthood, and you've got how many convictions of misdemeanors and felonies do you have as an adult? I see 2 misdemeanors of evading detention and assault of bodily injury of a family member when as misdemeanors. But what about felonies? Because there were several, more than one case where you were placed on probation and then your probation was revoked and you were convicted. And then later on, subsequent to that, there are some robbery convictions, aggravated robbery convictions. So how many felonies do you have?
19, 4 or 5.
They're 5. Okay. So we place you on probation here for evading arrest or detention. And he's pleaded true. There's no agreement here, right?
No, Judge,
Okay.
the office for 18 months, which is the most that he could get.
Cap of 18 months.
Well,
That's
what he
when
could
he was
get.
put on
Yeah.
probation originally, right? So you're looking at no less than 180 days up to 18 months in the state jail. State, you want to go first and last?
Judge, you know, I would ask for 18 months. Speaking with probation, it's either the 18 months or they're willing to still work with him if he's willing to go to safe P. If there's a problem there and he could go and complete safe P, come back and be on probation.
That's right.
Yes, sir. And that's what I have spoken to Mr. Faulk about, and he is interested in taking advantage of that safe P option.
No, I'm not
and cleared.
talking about interest. I mean, would you do it?
Yeah, he's willing to do it. He's motivated to do it.
Yeah. Is that
Yes, sir.
the nice lady speaking for you? But I want to hear from you. Is that what you want? It helps. It helps people.
Yes,
But
sir. I go to program.
But you've got some problems here for a long time that you haven't resolved. And this could help. But you've got to put in an effort. Are you willing to do that?
Yes, sir.
Okay, so I'm going to find that there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater as allegations 1 and 3 are proven true. I'm going to hold this motion, I think, in abeyance is the way to do this. We are going to modify a term and condition of probation to require you to attend and successfully complete the substance abuse felony punishment facility program. Do you understand where we are on this? You gotta do the heavy lifting. You gotta avoid the drugs. But it's obvious your home life was a wreck growing up. I mean, it's obvious. I've seldom have I ever seen a child with that many dispositions, and it must have been a difficult family household, I presume. But you're an adult. You got to handle your responsibilities, fix this so that you can move on the best you can. Are you promising to do your best?
Yes, sir.
Okay, do it. All right. We'll continue on your probation and complete that substance abuse program. All right, and do well. Thank you. Vicky Holloman. Vicky Holloman.
Okie dokie, friends. I told you earlier that I had my eyes on Judge Simpson's court for this evidentiary hearing with former U of M coach Moore. But it's not happening yet. I wonder if they're negotiating behind the scenes to put an end to all of this, because they've had it queued up for like 2 hours now. It's just not going anywhere. But it is a Friday. So what do we do here on Fridays? We go to that place in southern Ohio, Appalachia country, where justice is best served in a cold, dank basement with a cranky judge, the screams and moans of the dead echoing from within the walls, the Soviet-era lighting, and a printer that never stops running. If you're new here, this is our guilty pleasure. Enjoy it, ladies and gentlemen. I give you Dungeon Court.
So from this, I think that he's gonna go inpatient after the crisis center.
That's the recommendation, Your Honor, for a 3-5. I stopped over the other day and spoke with Mr. Conwell when we established the determination of level of care, just so he understood what was going on. Obviously, his desire is to return home, but he said that he would be willing to follow the recommendation.
Okay. All right, well, they're recommending that you do some inpatient work for a while. So why don't we come back fairly quickly, to keep a handle on, see how things are going. So,
That's fine, Your Honor.
what dates are not available?
Last 3 Mondays in March are not good, so.
Okay. Well, probably gonna need to do, when it's not a Monday, can you do the 20th? That's 2 weeks from today. All right, I'm gonna set it for the next hearing for March 20th. For a pre-trial, 10 o'clock.
Thank you, Your Honor.
Okay, you are. All right, Mr. Conwell, I'll see you in 2 weeks.
I'll see you, sir. Thank you.
You are.
State of Ohio versus Dalton Griffin, case number TRC 26-200.
Your Honor, Mr. Holt has been retained in that case. I believe he's also filed a motion to continue.
Well, if he has, I'm not aware of it. Are you, Mr.
The state has that motion. We just looked at it this morning.
Okay. Dalton Griffin.
Well, I got a discovery demand from Mr. Holt. And what else?
It's not the court's file.
Notice of appearance. Well, these are originals and they haven't been filed. I don't know whether they were supposed to be filed in the case. Maybe they were. And then a request to reschedule the hearing for Monday, March 9th. So I've got originals here, if that's suitable for.
What's the state's position on it?
We're okay with that.
Okay. I'll go ahead and reschedule it for March the 9th as a pre-trial.
I don't know.
At the defendant's request.
I need to find out if the court got copies of this. All right, well, we'll do something. State of Ohio versus Crystal Justice, case number TRC 26-203, A and B.
Surratt's case pre-trial.
Your Honor, we pre-tried those this morning. We're going to get some medical records from Ms. Justice, and I think the state wants to see those also. Also, I think we need to file for discovery because I think there's an issue or two that we need to address, so we just need to set for another pre-trial.
27th of March for or thereafter?
27th is fine.
March 27th.
Can you get it by then? Yes. Okay.
For pre-trial, 10 o'clock.
That shows that. Okay, right, good.
Okay, good deal.
State of Ohio versus Christopher McBride, case number PRC 26168, A and B.
So you, on Mr. McBride's case, Your Honor, I know that we need discovery on it, request discovery. Also, I understand the state has said that they're missing the narrative and the video on the case, and we need to get that from the state, and the state needs to get it. Fantastic. Good. Good. How long do you think
Your Honor, there was a South Point police officer that initiated the traffic stop, and then it was turned over to the Highway Patrol. So we're going to get a statement from that officer as to why he made the stop in the first place. And also we will get the video evidence from both officers. And I guess you're going to file discovery.
Yeah. So if we could say maybe the first part of April, we'll waive time.
Does it matter if it's Monday or Friday?
April's pretty clear, Your Honor.
Let's do the 6th, April 6th. That's a Monday. 10 o'clock, that's a definitive
State of Ohio versus Bunting Spears, case number CRA 25498.
April 6th.
Thank you. Sure.
Good. You took it off last time.
Yeah.
Right. Did you? Yeah. He's an outpatient now, Your Honor. So.
Are you working, Mr. Spears, or what's?
So I just got to outpatient 2 days ago. I was in Portsmouth and I transferred down to Ironton Transitional and then went to outpatient. I start a job tomorrow at Calma.
Okay, good. All right, just keep monitoring then.
Yes, Your Honor.
You know what your work schedule's gonna be?
No, not yet.
Okay, so you don't know whether a Monday or Friday is better?
No, not yet.
Okay, let's come back mid-April, what's your schedule?
The only date that's bad is the 13th.
17th, April 17th?
Yes.
April 17th will be your next hearing.
17th.
Mr. Spears, good job, keep it up.
Thank you, sir.
Thank you, Your Honor.
State of Ohio versus Todd Twyman, case number PRC 11708, CRB 11751, PRC 10189. I understand he's on Zoom, Your Honor.
All right. I have Mr. Steyer as the attorney on the.
I didn't catch the name of the client.
Twyman.
I don't have that on the document.
It's an old case.
Okay.
You had represented him initially. I think it was set for a hearing on March 2nd. Twyman apparently was not here then. Mr. Twyman, you're present on teleconference?
I'm here, I'm on video.
Okay. You say you missed Monday, is that right?
If there was a review here, and I wouldn't have known about it necessarily.
Right. Mr. Twyman, you were supposed to be here Monday for a review, is that right?
Can you hear me?
I can hear you. Can you hear me?
Yes, sir. We had an ice storm up here by Marietta, and I talked to your clerk, and she told me to make it down there today. I talked to my probation officer yesterday saying I wasn't able to make it. My wife's going transportation to take off work, so I've been live online since 9 this morning.
He has contacted me, Your Honor, and I gave him the information to get him to at least make an appearance.
All right. Well, you got a lot to do. You've got community service and funds and costs to pay. How are you going to take care of this stuff?
Yeah, well, I have 48 hours for my community service. My wife's going to email him. I just learned how to verify that with my probation officer yesterday. I won't be able to
Apologies, ladies and gentlemen. Hang tight. OBS crashed in the middle of that. No idea why. I'm queuing it back up. I have no idea where we were in the feed, but we're going to pick it up right about here because that's where we're going to pick it up. So here we go.
While we're trying to get him some help and treatment, then the state will revisit how they need to handle that, depending on how well he does in treatment. Am I correct?
That's correct.
And we do have, and maybe not coincidentally, it's available Monday, which is the date, I guess. He was
Okay. I think he pled guilty at the arraignment. I just said it as sentencing. I don't know if you want to, it was unrepresented.
Yes, Judge, and if I didn't do that at the time I was appointed, yes, I would withdraw the guilty plea on the domestic and ask that he be considered for treatment, inpatient and residential treatment of Bethesda.
Okay. Let's get that out of the file. I had actually set it up for a review initially on March 30th. He wrote me a letter, it's coming back now, asking for some relief from his jail sentence. So I told the clerks to put it on for March 9th, so that's should be in those files and reviews. Okay, is there anything we can do here while we're waiting on that?
Yes, sir.
Okay. We'll come back to it when we get the file.
Yes, sir.
State of Ohio versus Nathan Perry here at the court, case number CRB 2634, PRC 21940.
Okay, this is Nathan, you're Nathan Perry.
Yes, sir.
This is on the sentencing docket. Okay, and you were supposed to go to OVP and get an assessment.
Yes, I went Monday, yes.
Do you have anything from them?
Yes, they leave me on outpatient. I have another appointment with them on next Thursday.
all this is just an appointment. It's not anything, I need a report from it. Here's the other thing, I mean, you've got an OBI from 2021.
Yes.
But you haven't done anything on.
No, I lost my job, and I've had a very, very tough time just trying to survive since. At the time I was working at Speedway, and then since I've been having to work for myself, and then most recently here, back last fall, I started working for a buddy of mine, doing heating and air, as well as my own handyman business that I do.
Well, man, I arranged you on this on January the 16th, so.
Yes.
We're 6 weeks out.
Yeah.
And in 6 weeks, you haven't done a daggone thing on this ODI that's been pending for going on 5 years. Explain that to me.
Yeah.
I mean, you knew you had that.
Yes.
And you got 6 weeks to get in there and do something. You haven't done you haven't paid a nickel on your fines. You haven't done 1 day of community service. You haven't gone to the driver intervention program that you were supposed to do.
Yes, sir. I have not worked. I worked this week was the first time I worked since February 9th.
You don't have to work to do community service.
Right.
Explain to me why you couldn't get in here and get some community service done in the last 6 weeks. You don't have an explanation.
No, they're not.
Well, I think what you need to do, you need a weekend in jail. So I'm going to order you in contempt for not doing something on your case. And be transported to jail. He can be released Sunday at 5 p.m. And then I'll set your next hearing for April the 6th. I'll give you another month, and you need to start taking this seriously and get it done.
Your Honor, if I may request, I do have a job that I was supposed to be doing this weekend. That I would be able to pay on my fine.
You're going to be in the jail. You're commanded into custody. Take this serious and get it done. April 6th is his next hearing.
State of Ohio recalls Joshua Turner of Lawrence County Jail.
Okay, we need the jail back up. So I've got the other file now, 25/6/25, and I had moved it to March 9th.
I'm trying to call me on this busy.
Okay.
We've got something else we can do here if you'd like.
Okay, I am going to go ahead, and you can pick him up on March 9th.
I'll pick him up
Some of these go on your driving record, like the careless driving.
Okay. So Dungeon Court is telling us to be done. That's clear. That's twice it's crashed, and OBS has not crashed on me in months. So we're just gonna cut our losses, and we're gonna call it a day. I mean, we only got like 5 minutes to go anyways. But I hope you guys had fun this week. I know I did. Some good court, a new judge that we like. And yeah, some good times. So thank you all for joining me. We'll be back on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier for channel members. We will be posting videos throughout the weekend. Barbara asked me in the chat about the best of streams. We did those for a few weeks, and we did them as a test. And the test was successful. So they will come back, but now I need to work on a system to get those done efficiently, because those took a lot more time to build than I want them to, and I work off of systems and routines here, so we're working on a system to build those proper, so they'll be back in the hopefully near future. Anywho, like I said, we'll see you Monday. Have yourselves a great weekend. Stop by the channel for some videos and shorts at some point when you have the time, because we'll have them, but enjoy yourselves. See you Monday. Take care. God bless.